Have you tried T-posing on it to assert dominance?
I'm not. Okay, now it says it worked. We will see if that's true in a moment. Also, I need to get rid of these old ones because it made like 4 different streams. Chat restream sometimes just does not like me. That's the unfortunate reality. But it looks like it finally decided to do what I asked it. We're good. Thank you all for being patient. I'm gonna have to make a new chat goal now. Oh no, wait, the chat goal is still there? Does it just put it across your entire YouTube channel? That's weird.
I think it does.
Anyways, chat. Today, we've got going over Ethan Klein's filings, because even though, like... So we do have to issue a correction, because we both fucked this up. You cannot...
A massive one, yeah.
You cannot use anti-slap on copyright cases, because copyright cases are considered federal. And anti-slap is more of a local law
Yeah,
thing.
so because these cases, for instance, were filed in the Central District of California Court. That is the federal court for California. Because copyright cases are federal in nature, state-level anti-slap statutes do not apply, which means that this is free and clear to get past slap and go to discovery.
Yeah, which we should have known, but on my part, admittedly, I do not like copyright. It was
totally my bad.
Yeah. Ava should have known because it's even her district. Yeah.
I know, Jeff. Look. I've never done like any copyright law shit, and it slipped my mind that copyright cases are federal.
Yeah, that's that was also my excuse. Is I'm on record multiple times. I hate copyright and trademark law. Because even stuff that seems like it should be really clear cut and simple is absolutely not when it comes to copyright and trademark.
I mean, trademark and copyright law is really specific, and if you can get even more specific with it when you get into patent law, which requires that you pass a special bar exam to become a patent attorney. Like you can't even be a patent attorney with your normal bar exam. You have to take an elevated one that like has special fucking questions and shit.
Yeah. So even though we should have known, I think we deserve a little bit of grace on that, because it is probably the most confusing segment of law, at least in my opinion.
I think the grace is the fact that we admitted that we were at fault and then we corrected. I think that's the grace that we get.
That said, we have 2 corrections, because we have that one. The second one is because we did not read Ethan Klein's actual filings. We didn't realize how retarded he is. Because his video makes it sound like his lawsuit is just, I'm just including all the points where they maliciously used my video and where they said they maliciously used my video. In reality, his filings are 40 pages of him debating with them.
Yeah, there's a lot of fluff and irrelevant info, but here's the thing, because anti-slap doesn't apply here, this is kind of like, this is an area of grievances, right? This is the one place for him to do this. Now, when it comes to future filings and stuff after discovery, and like when the case actually starts and goes to trial, absolutely not. You can't be doing this. But for a main document for like a initial complaint, this isn't too over the line.
Yeah.
Personally, for me, it is because I see that we should have a federal anti-slap statute in place, but we have the fact that Caseytron, Frogan, and Denims have the elevated standard that's not even required by copyright law. They explicitly stated their malicious intent to become a substitute for the copyrighted work. That is pretty much as textbook 101 copyright infringement as you can get.
The head pats work now? No, I have a button I have to hit for it. So I'll pay attention to what people say.
Yeah, we both have buttons.
The Akko said head pat the elf, head pat the puddle for 5, and Toa for 5.
To be fair, my plugin stopped working.
Fair.
I've tried it I've tried typing in using 3 times now. It's not working.
I'm just using my
But you should probably headpads.
Toa for 5, copyright mention. IP is any law that I can invoke that allows me to control the conduct of my competitors, critics, and customers. Corey Doctorow? I'm sorry, I don't know that quote or who that is. I probably should, but...
But yeah, I mean, I don't think Ethan's 40+ pages of debating these creators with stuff completely unrelated to the actual content Nuke that was infringible, right? And we're talking like, literally like, oh, Denims one time said this on stream, here's a link disproving that. It's like, this is not needed. Like, as far as like the complaints themselves, I definitely would have done them differently, but they definitely still hold enough weight to move forward to discovery, in my opinion.
Magma for 5 had pat both the lolly and the prose Shota. So chat, I cannot for the life of me make it work for Shota. Like everything just sounds too wordy.
I know, it's really hard.
The ones I came up with were prosa Shota, like prosecutor Shota, and prose Shota, like prose Shota. We also had prosciutto, which was my third suggestion.
What about just Pro Shota?
Yeah, Pro Shota. The lolly and the Pro Shota.
Pro Shota cuter.
Somebody said that one, and I was like, I don't know how I feel about that, because that makes it sound like executor.
Hey, you know what? Let's be real. You've been doing a lot of executions lately.
Apparently.
It might be appropriate.
Apparently, even the annoying elf has made a comment on me now.
The annoying elf? Who's that?
Alara.
Oh, okay, gotcha.
But I kind of ignore her.
I'm the only annoying elf allowed here.
Different kind of annoying. StreamYards hate me today. Sometimes when stuff doesn't pop up. What's StreamYards?
StreamYards is it's a multi-stream platform that Legal Mindset uses.
Oh. I don't think I've heard of it. I'll have to look it up. You're taking her advice and ignoring her. Yeah, no, chat,
like... bono instead of pro bono? That's pretty good.
At fair. But chat, the big things today are reading Ethan Klein's at least one of Ethan Klein's documents, because they're ridiculous and they're stupid. And the second one is to cover this new ruling over AI, which I had not had a chance to read through yet.
I managed to track down the order for fair use there. So we've got the judgment on that particular case. But yeah, AI can be protected by copyright.
Yep.
And fair use and stuff. Yeah, we'll get into that later.
Yeah. Also, chat, we're gonna go ahead and pop in. So this is the one we were going to cover. Back up to the top here. This one is Caseytron's. And I wanted to kind of...
Okay, so real quick.
Yeah.
Because this one's really good. This one's really, really, really good. But there is a clip, and I'm gonna try to find a clean version for you. I found and timestamped it in the DMs. Me reacting to it, but basically she's trying to say that Ethan Klein doctored her actually reacting to the video, and she doesn't remember reacting to it because she was under the influence. And I got extremely angry.
I'll just play your clip on it. It's fine by me.
Your video, like... I don't know. I don't recall reacting to it. I don't believe that I reacted to it. I do not remember. I don't know. I may have been under the influence, but I do not recall reacting to it.
Look, lad, you guys know, everyone here knows that I smoke a shitload of weed. I mean, not a lot, like not a ton, but I smoke, that's just me disowning Caseytron as a weed smoker. 3 to 4 times over a strain, right? But yeah, that was her actual words. She smokes like, what was it?
Because Eva is a cringe piehead, but it's okay, we love you.
Well, here's the thing. I'm a piehead who passed the bar via reading of the law, okay? Like, clearly, weed is not the problem. This person's just really that stupid.
You know, weed's not the problem, but it is a problem. I'm gonna be the straight-laced one.
Yeah, the problem is I don't have enough of it. No, I'm kidding.
Totally not an addict. Don't worry, Chad. I can stop anytime I want.
I've never said that though.
I know. I'm just saying. No, I'm just messing with you. You're good. So was there anything after that, or was it just her saying that I don't remember?
No, it's pretty much. You could go back a little bit more. Yeah, she said that, and she also said, "How pathetic do you have to be to doctor me smoking weed over your stupid video," or something like that.
Just because I didn't react to his stupid video, he had to make up that I did and put a video of me smoking weed over his stupid video to get attention.
Oh, so she straight up says she did not react to it. Like, right,
that's the thing. She's saying she didn't react to it. Ethan doctored and pretended that she reacted to it, and then she doesn't remember she reacted to it. There's like 3 defenses that are absolutely bullshit that she gives in this 30 seconds.
Okay, so she's going for the didn't happen approach.
Yeah, it's pretty bad. Or if it did happen, I was so high I don't remember.
Yeah.
And again, I smoked weed all the way through passing, like studying for the bar, right? I don't recall. Maybe that's it. I don't remember forgetting, but I did forget. Oh shit. Yeah, no, this is an absolutely legal mindset calls it debate defense, and yeah, it's overcut. It's an absolutely atrocious defense.
Yeah, I don't see it. Eva's stream layout looks great. Love the color scheme. It is pretty. I'm trying to get a new one for myself soon. But chat, we're gonna go over specifically.
You know what's really funny about the layout?
What?
I made I got the layout before I got my outfit, and the outfit just came out like matching my layout. Like I didn't do that on purpose.
It's just luck. But chat, so me and Ava actually kind of looked over these first. What's weird, so I want to show this because this is just weird. It's not like a big deal. It just threw me off. Is these all have different layouts. I'll put this back in 2-page view so it's easier to see. These two have the exact same layout in every single way. And then this
it's formatting differences between the different court that they did for state. Because Caseytron's is a different state.
Fair.
It's the Western District of Missouri. So that is why the formatting is different.
Just threw me off. Also, chat, don't think that just because it's not up here that they didn't do it. No, at the very bottom, they are requesting jury trial again. Always requesting jury trial.
Yeah, they are. It's a demand for jury trial on all 3.
Just this one, it's at the very bottom here. Jury trial demanded. I don't know why he's like so insistent on this jury trial thing, because I think jury trial is the only way he loses it. Because if I am defense's lawyer, I'm constantly bringing up how he's debating them all the time, how he made the video where he said he intentionally baited them so he could sue them. Because, like, the average person doesn't...
Right, but that's all on, like, okay, well, he's a malicious litigant, which is completely fine because this is a clear and concise example of copyright infringement, and anti-slap statutes are not in place.
Yeah, that's what I'm saying.
That's what
the jury
malicious
trial
litigation
thing.
would be protected from.
I think you can easily like
But
convince
that's
a
the
jury
thing.
trial.
Jury won't let you. They won't let you argue like that. The judge will not let you make those arguments.
I don't know. Because he's brought it up in his filings, so I'm allowed to address it now. Because he's made it a point of contention.
That's true.
Because that's why this like hurts him so bad. Is he links his own video in these. And I feel like it's pretty easy to get the judge. Like, Judge, what do you mean I can't bring it up? He brought it up.
Yeah, I mean, okay, so it could probably be made a point, but the fact that, like, it's an irrelevant fact to what happened, which is the copyright infringement, right? And the jury has to weigh on whether or not that infringement happened and what the damages would be and all that. But him being malicious and catty about it does not change that fact. And the jury's instructions would be, did these people infringe on copyright? Whether or not Ethan's being a dick in his filings.
I think
is this what they did? The jury will have to find that they did.
I think that's easy to pass with a jury, though. That's a lot harder to pass with a judge. But with the jury, because we see this all the time with just regular people, is nobody understands fair use. And it's very easy to convince somebody that just about anything is fair use. But so I don't understand why he's so insistent
just because there's a demand for a jury trial doesn't mean he's going to get it. It's very possible that the judges might nah, this is a very clear matter of law, and I'm going to do summary judgment instead. Because you don't have a right to a jury trial when it comes to civil torts.
I am, when like I'm analyzing this, I'm analyzing it in Ethan gets everything he wants, basically. He gets a jury trial, he gets everything in this document admitted, like, 100%. And I'm like, I don't think that looks good for him in front of a jury.
You could bring up all the filings verbatim and wear down the jury. That's true. You could get the jury just so tired of hearing about this. They're like, you know what? We don't even fucking care. You deserve to lose on principle.
Yeah. Like, that's my thing, is my assumption when I analyze stuff like this is that the plaintiff gets all of their filings in and they get exactly what they want, which isn't always true.
Anything over $50, isn't there a constitutional necessity? If it wasn't, no. Your constitutional like rights are only like guaranteed if the government's trying to like prosecute you for a criminal offense.
Yeah.
You know, like if they're trying to criminally prosecute you for something that you say and they don't give you a lawyer, not only are they violating your First Amendment rights, they're violating other rights as well that were obtained later after the writing of the Constitution, because people don't realize this. The right to a lawyer wasn't always a thing, and it's not always a thing, especially when it comes to civil torts and litigation. You're really only guaranteed a lawyer if you are being criminally charged with something. The state will provide a lawyer for you. That's about as far as that goes.
Yeah. Also, good on Caseytron for not moving out to California like everybody else when it's completely not necessary for a digital job.
Yeah, no, Missouri's.
Something I never understood with like YouTubers. Like, you need to move out to California to network. It's like everything you do is online.
Dude, they moved to California or they moved to Texas. And it's like, guys, stop it.
And it's never like out in the country or something. Like, if you're gonna do it, at least do it like out in the country, right? Where it's cheaper. But no, you always move into like fucking LA.
Exactly. I mean, you know what's really, really upsetting to me right now?
What?
There is a deal going on. I just paid, I got my YouTube check-in. And I had to pay the whole thing to our Jeep registration because we're registering the Jeep in South Dakota to avoid having to do smog or anything like that with California laws. But the initial cost for that is like $500. Today, this morning, I woke up to see Starlink offering a full waiving of the equipment fee if you just pay for the first month. And like all that. And I'm like, and I don't have, it's like $80 to start with Starlink right now. And I have no money. And I'm so mad because it ends in 2 days.
How much is it?
I'm like, that's the timing of the world. I'm not sure. I think it starts out like $80 off the gate, and then it's $120 a month.
So you what? You need $80
but
in the next
they
2
are offering
days.
it full waiving. I don't know that I could do it that fast. Is the thing. I'll have to see.
Bro, I'll send you fucking $80 right now.
Oh my god, don't do that.
It doesn't bother me. I'm in a good spot right now. Talk to me after stream. Consider it payment for the first 2
yeah, I'll talk to you after
Lawtisms.
stream about it. Okay.
Chat, let's make Eva $80.
Yeah, residential light.
Start doing them head pats.
Yeah, guys, you need to start giving them head pats.
But we're gonna go over this one of Ethan's documents specifically because it's shorter than the others. And the reality is he repeats himself a lot in these, so I don't see any reason for us to choose like the 80-page one over the 50-page one. But this was another thing that he does this on all the documents. He has like this meme exhibit he does at the top. Again,
yeah, which I mean,
kind of catty behavior.
You're allowed to include. It is catty, and that's the problem. But like, you're allowed to include images with your main complaint. There's one that does it very well. Actually, I'll have to look that one up because it's like, wow, this is actually one of the best federal filings that includes images that I've ever seen. But like a justice is gonna look at this and he's gonna roll his eyes.
Yeah.
I guarantee you, he's gonna roll his eyes. He's gonna let you get away with it, but it's like, come on, really?
Yeah, it's one of those things, like, it stacks up a little bit, Ethan, where you kind of wear out the judge, the jury. Like, you could be the most right person in the world, and I've seen judges just genuinely get so annoyed with a person. They're like, you know what, you lose on principle. Get out of my court.
Yeah, because that's another huge thing is people have to understand copyright cases are totally up in the air. It's completely within the mindset of the judge what happens. Like, one judge might rule that something is fair use while the other one is not, and it's on the same exact issue. It's never a one-in-one what it done. It's not a universally applied rubric that we have for judges to follow. It's completely at the judge's discretion, and for that reason, yes, you absolutely want to keep these complaints short, concise, relevant to the topic at hand, because if you don't, the judge absolutely might be able to, you know what, this is fair use, fuck you.
Yeah.
The judge could do that.
Elise Serrano for 5 CAD. Weed is not the problem. The problem is the booba bat and her quest for new cleavage to perch on while she does lawyer things.
I'm sorry, what?
I don't know. Apparently you have a booba bat.
I can become a bat, but first of all, I need boobs to have a booba bat. Okay? That's rude.
But no, I was gonna say, there was one court case I remember watching where it was a pro se defendant, and the pro se defendant, like, definitely did it. It wasn't like a criminal trial, but they were really nice and polite, and they came out of the gate with like a one-page, what do you call it, opener, and then the fucking plaintiff had like 10 pages of just absolute bullshit nonsense. And at some point the judge was like, you know what, defendant wins, just because he's not wasting my fucking time.
and obviously that can be appealed, and you can argue that the judge was the judge got too close to the case and got like their feelings involved with it, and therefore wasn't. So there's arguments you can make that.
Yeah.
But absolutely, it's why rule number 1 when you are a trial attorney is don't piss off the judge. Don't do it. And you can piss off the judge in a number of ways. And the number 1 way is usually wasting his time and the court's time.
Yeah. This is some of his strongest stuff, is the quotes from them. I know a lot of people have been wanting to watch this without necessarily
supporting Ethan. She smoked more than she spoke. I'm sorry, that is a good bar.
I know a lot of people have been wanting to watch this without supporting Ethan Klein, so we're going to watch it. and what is happening I'm trying to follow, but I lost the plot. This second one, though, I don't think is as strong as he makes it. Because you can make, like, a billion excuses for why this is confusing, especially considering when she said this, he was playing a clip of Hitler. Like...
Yeah, I mean, there are parts of Hassan's content, Nuke, that I remember, that I'm like, where are we right now?
Like honestly,
absolutely. Like I lost the plot a couple times, and I was not nearly as high as Caseytron, so I get it. Like, this is not a strong argument to be made. The first statement, absolutely. That speaks to intent. Yeah, exactly. This is the big one right here. The second one, not really.
The problem, because this is the problem I see a lot of times, is it is somewhat correct in court that you should sort of kind of throw everything up against the wall and see what sticks. The problem is if you throw too much at the wall, other stuff stops sticking as well. Because then people are like, okay, you're fishing.
Loses its adhesion. Exactly. Well, yeah. And if there's a complaint that has far too much in it, absolutely. The thing is, though, like, usually prayers for release or requests for release are usually in the for instance, Pixies is like 14 counts for prayers and relief, and then even the Tyler Carey sex abuse case, that one has 10 counts. So as far as like his actual counts for relief, he only has 2. It is relatively short. But I'm saying it could be shorter, and it could be far less more impactful if he didn't have all the fluff that we're about to go through.
I wanted to double check this lawyer again, right? Because one of my things that made us think that somehow this was related to anti-slap was the lawyer himself is an anti-slap specialist.
I think that is part of what got to us, yeah.
Focuses on First
as an
Amendment,
anti-slap specialist, he would know that filing is copyright. Because he's alright, he's very clear. Yeah. Look at that, oh my god, I'm sorry, he looks so smug. Yes. His smug aura mocks me.
I have one of these that you can see in better chat. Yeah, this is the attorney Ethan hired. And up in the corner here, it says First Amendment and anti-slap matters. So it's kind of like, okay, so he knows what he's doing with anti-slap. But then it also has copyright and trademark. Yeah, I will say this is weird stuff to have together as a specialty, considering as we found out, anti-slap and copyright literally do not mix. You're specializing in two things that have nothing to do.
That kind of makes sense. Which is fine. That's a lot of people will end up taking a lot of.
I think.
Yeah, that stuff works together, and then his copyright and some of the other things, which are more federal, like he probably focuses on copyright and federal separate than probably everything else.
Yeah. I just think his specialties are a little all over the place. Especially because a lot of like really good lawyers I've seen have like 2 specialties listed. They're like, yeah, this and this.
That's true.
Typically and this isn't always true, chat, but typically in my opinion, when a lawyer starts adding a billion specialties to their page, they're a bit of an ambulance chaser.
You know what? Ron Barnessim looks like somebody who enjoys the smell of his own farts, and that's why he's smiling.
True. Take it, some of these specialties take years to be certified in. I mean, you're not really certified in like something like that most of the time. Usually you go to you pass your LSAT, you go to law school, you pass the bar, and then it's up to you to decide what area of law to study. But there's not a ton of law areas that require like a special certification or a special bar. Yeah.
Patent attorneys, for instance, are one such exception. But no, generally speaking, after you pass the bar, you become an attorney in your state. It's then up to you what you want to study, get specialized in, etc.
Lawyers typically choose,
but you don't actually need a certification for copyright and a certification for anti-slap and a certification for defamation. No, that's not how that happens.
Yeah, lawyers will typically choose a specialty chat because the law is very dense and it's constantly changing. And if you decide, I'm going to specialize in everything, you're not going to be able to keep up with the landscape of like how it's changing, and you're going to fuck up your cases. Because you're going to show up to court one day and you're really like, actually, there was a precedent-setting case that came up on this last month, so all your evidence that you have is bullshit. And you'd be like, well, I've been like studying this specialty and this specialty and this specialty, so I didn't know that. And then you're gonna look like an idiot and you're gonna fuck up your case. But yeah, it's not saying he's bad.
And then you pull it, Chuck.
I'm just saying, anytime I've seen a lawyer that lists a billion specialties on their page, they typically end up a little bit of an ambulance chaser.
Well, that's the funny thing about ambulance chasers. They're pretty specialized in only a few areas of law.
True. They're typically,
So, like, this guy is actually more spread out in terms of his specializations than your typical ambulance chaser.
Massive Doge for 5. One way it goes in favor of Ethan is if Judge Samuel Hyde takes the case.
The Son Pico!
I will say, I don't think a lot of people watched Ethan's video, at least as much as he thinks did. At least, like, not all the way through. I saw a ton of people that were assuming that he was suing Hassan. Ton of people. I'm like, that doesn't come up anywhere.
I think he wanted to. But Hassan, like, ended up, like, reacting to only half of the content new. And it took him 9 hours. So, like, any judge is gonna look at that. This is transformative as fuck, dude.
Yeah.
Like,
sorry.
this is the most, like, okay, your content nuke is an hour. This guy was acted to 30 minutes of it in 9 hours. I'm sorry, but this is more Hassan content than yours.
Yeah, this is actually one of the things I think is gonna hurt him on the Denims case as well. Because, like, he could... Like, yeah, she watched the whole thing, but she watched the whole thing over the course of 5 hours. I'm like, I'm not saying... You're gotta, like...
That would I would make the argument that's that's by definition transformative.
You're gonna have to really knuckle down on her quote and, like, really emphasize that when you're making that case.
Yeah, it's the malicious intent. Yeah, that one's gonna be hard.
Because then you're gonna have to argue she did something maliciously, but did what she do actually break the law? Or not the law, but the requirements for copyright. And that's now going to be your argument you have to make in court.
Right? It's like, look, she stated her intent, but she was just so stupid.
She didn't manage to do it.
She didn't realize, it's like she didn't do it right. But
it's like in some areas of law, intent is enough.
It depends too. Like she reacted to the hour and a half of content. Now, was that spread out over the 5 hours, or did she watch it largely uninterrupted and then talk about it?
It was spread over the 5 hours.
4 hours or 3.5 hours. Okay, so what's spread out over the 5? Yeah, that's gonna be a hard case to make. Oh, headbats.
Yeah, I got one too. That is because there are some like specific legal theories where the intent to do something bad is enough, but I'm pretty sure in copyright, no, it either is or it isn't.
Copyright, no, intent is not a factor. It's whether or not you actually infringed all the copyrighted material. Now, what I will say is Ethan has done something far better than what most people do, which is he registered his copyright with the Library of Congress. This entitles him to statutory damages that he otherwise would not be entitled to had he just relied on the natural copyright protection that is created upon creating a creative work.
Yeah. Bug says, Your Honor, my client is malicious but dumber than a bag of hammers. Introduction. The lawsuit is about ending the practice of lazy reaction videos that copy entire works and purposely siphon viewers and revenue from the original. Over 7 years ago, the plaintiff TED Entertainment Incorporated, TEI, Ethan and Gila Klein, established a legal standard for fair use reaction videos in Hosena's, I can never pronounce that fucking. In Ethan Klein's previous case. As a genre, reaction videos vary widely in terms of purpose, structure, and the extent to which they rely on potentially copyrighted material. Reaction videos, like the Klein video that intersperse short segments of another's work with criticism and commentary, constitute fair use. In contrast, reaction videos that are more akin to group viewing sessions do not. I would say this, I do not think this is necessarily correct when he says it established the legal standard for fair use reaction videos.
It kinda did.
It established that what Ethan
like,
did...
in terms of legally and in the courts, it like, Ethan Klein's really was the breakaway case when it came to establishing what kind of limitations fair use actually have or not have. No, I'm not saying that, like, it's great what we were given with that judgment, but what I'm saying is that it did kind of establish what a lot of judges will use as the standard, because this case is used as that.
I will say, my issue with that is because he was the defendant in that case, he more so established how much you can do, not necessarily what you can't. Which is where I think he's going to encounter a problem with that.
Yeah, okay, that's fair.
Because he's going to be like, see, I established the standard of how far you can go, and if I'm defense, I'm like, you didn't establish how far you can go, you established that what you did was not breaking it yet. So we still have not found the edge yet.
And so he can use that and say, and I'm saying as somebody who was tried and found to have not violated fair use, I am saying that this heightened standard of stated malicious intent on top of the infringement that happened does meet that standard. I can see that being a decent argument, given him being a defendant in a fair use case. Him going, look, me no more than anyone, given I was sued for this once, should know what the standard and where the line is, and I'm saying this crossed the line.
Yeah. I don't know, if I'm defense, I'm pointing out, like, how often Ethan has no idea where that line is.
Yeah, that's fair.
Because you can't, like, prop yourself up as an expert on something, unless you, like, literally are an expert.
Well, and he's mentioning his case here. It's relevant. I think it's a little bit of a self-flex, but it's relevant enough. I'm not gonna, like, give...
Oh, no, it's definitely relevant.
Negative brownie points to it or anything.
He was being sued from, like, some outside company.
It's a copyright case.
I don't know, because a couple times in here he mentions the fact that they played the whole Nuke as one of the factors. And if I'm his lawyer, I'm pointing out that, you know, in your case, you played the entire thing start to finish with no commentary. And you gave the commentary afterwards.
What?
That was what some of Ethan Klein's original case was, is he'd play entire videos and then he'd give the commentary after the video.
Oh, I thought
that's very
Ethan Klein
common
was
on
always
YouTube.
pretty transformative when it came to his reactions. I remember him splitting things up with, like, skits and like actual like he'd go out and like JonTron reactions kind of thing. I thought he was more along the lines of that kind of a reactor. I didn't know he did watch the whole video and then comment on it after.
He'd do a little bit of column A, a little bit of column B. Sometimes he was lazy or sometimes he wasn't.
Gotcha.
Because some of his things weren't reacting to one video. It was reacting to, like, dozens of videos. And he'd do the skits in between the videos themselves.
Okay, gotcha.
Nerdy text an accountant for 5. Help the elf. Also had pads for Eva and Mizutamari. I think your head pad is longer than mine. Mine's only, like, I think 10 seconds. That might hurt his case. That's what I'm saying, is because he's now, like, opening himself up to some of these questions when he's like, actually, you know, I'm kind of an expert in this field because of my previous case. It's like, okay, well, let's look at your previous case. Actually, you were, according to yourself, violating copyright pretty fucking hard based on what you're suing my clients for.
Again, I would just argue relevance to this case. We can litigate his violations of copyright later. But the purpose of this court session is to determine if this copyrighted material was infringed upon by these individuals. Us talking about the instances in which my clients actually violated other people's copyrights is completely irrelevant to this case right now.
My thing is, I can make it relevant because he has now cited that case directly.
I can make it relevant.
Well, no, that's what I'm saying. I can make it relevant because he's now cited that case directly.
I just,
and he's
that
like,
statement is so funny.
So,
I could see. I just look. My brain, like in my mind palace right now. Like we're in court. We're at like you're on your table. I'm at my table, and you just said in front of the judge, I can make it relevant, and I went, oh shit.
Yeah, no, because my thing is, Ethan is
but
like
yes,
such a braggart.
You could make it relevant because he brought up the case.
Ethan is such a braggart that I think it's going to end up hurting him because he's like, look at all the beautiful things I've done. It's like, okay, well, let's look at some of the beautiful things you've done. Since you put it in all your filings, let's talk about those things. And like, you know, obviously, plaintiff's going to be like, Your Honor, objection, relevance. I'm like, you put it in your filings, how is it not relevant? Why did you put it in there?
Okay, so Shinnok 5902, you're actually incredibly accurate. In regards to the jury stuff, I heard that when it comes to these cases, you can request to go from jury to judge without a problem. But if you don't ask for a jury from the start, you can't have one throughout the entire proceedings. That's true, and that might be why there's a demand for a jury trial, just so they don't waive their right to it later.
Fair.
That might be what they're playing.
If they actually push for it later, though, I'm going to say they're stupid. They should just want to be in front of the judge for this, in my opinion. But what do I know? I'm not the
Hero 101. I feel like they would be irrelevant to this case, but he would get sued the second he won this case. Yeah, because I think what would happen is like you'd be running litigation for like future cases and those defenses that you're making, because again, even though he brought up the case, well, what about this time you violated copyright, or this time well, that's not the case before us right now.
Yeah. That's something.
And so you might give a lot of avenue for future cases, but it's honestly a weak defense to use, and one the judge is gonna tire of far quicker than he would tire of Ethan's like fluff that he's added to the complaint.
Yeah, this is actually something I've said in the past in regards to YouTubers, is I don't think many of you understand that you don't want precedent. Because that's going to negatively affect a lot of you. You think you want precedent.
Like, that's what's being discussed in this case itself. People are like, oh, cool, awesome, sue these three. But people don't understand that these three cases could change like the landscape of copyright law and how we navigate copyright law, how platforms actually decide to enforce copyright. Like, this could change a whole fucking lot, and people don't quite seem to understand that.
Yeah. Like, we're already talking about how a lot of people go way too hard on copyright and try and make it way more expansive than it should be. And now Ethan's like, well, we need to clarify that a little bit better and make sure it stays difficult.
Because Ethan could get what he wants here, but he might fuck up the entire landscape for creators going forward. And in a way that Ethan will regret this lawsuit. It'd be like, oh shit, I didn't realize it would lead to this. But that's what this did. Like, you want to talk about content nuking. A lawsuit is a content nuke, okay? And these lawsuits could technically be actual content nukes and make it more difficult for people to pump out, react to, or comment on videos that come out. So yeah, this could change things.
Yeah. And like, I totally agree that some people go over the board and they probably should get kind of smacked with something. The problem is you have to be careful when you do this stuff, because in order to smack them without like a very narrowly tailored law that specifically addresses that, you're gonna smack everybody a little bit. This is kind of how it goes. This case concerns a group viewing session hosted by defendant Caseytron. I'm gonna use their internet names as much as possible. Caseytron specifically intended her group viewing session to siphon the maximum number of views and revenue away from TEI's copyrighted work, content nuke Hassan Piker the Nuke, to herself. Caseytron successfully achieved her objective by releasing her group viewing session of the Nuke minutes after its official release and showing it in its entirety. Caseytron greatly profited from her group viewing session of the Nuke through advertising revenue, donations, and paid subscription. I do think the argument of minutes after its official release is relevant. My issue with it in this case is he talks about her during it. So you kind of end up in this weird place where, like, if it was anybody else, I would probably agree with it wholeheartedly. But when it's specifically about the person that's reacting to it, kind of end up in that weird free speechy range where it's like, well, I have to address it because it's about me. Or I have a right to address it because it's about me.
You can address it, but in which you can address it, but watching it in a group viewing session, as they're defining here, and providing a substitute to the original thing does not constitute like you've gone above and beyond what your standard is to quote unquote like react or reply to your accuser, right? Like you are now actually violating the law yourself in your quote unquote response. You can respond to this in a way that doesn't infringe upon its copyright.
Yeah. But I mean, the copyright thing is going to be an argument no matter what. It's always going to be an argument whenever the video is involved. I'm thinking like some of the points he's bringing up would be stronger in a different context. And I think that's what's going to kind of, if he loses, it's going to be like a death by 1,000 cuts situation. Where it's like, yeah, you had this point, but it's kind of kneecapped a little bit by this other fact. And it kind of starts watering down all of his points a little bit. You didn't have to watch the entire thing, which I also agree with. However, the counterpoint to that is it's very common on the internet to shout context. You didn't play the whole thing. You clearly didn't show the context.
Yeah.
And Ethan Klein has also been known to do
That's actually extremely true.
The context thing.
Yeah, that's extremely fucking true.
I see it all the time.
When you said that, because, well, I mean, that's the thing too, like, because, and I've talked with other people, like Andrew, for instance, and more often than not, people are going to want you to react to the completed work rather than just an out of context taken clip, right?
Yeah.
But so long as you're actually reacting to it and like adding commentary and transforming it. The fact is here, and this is going to give them a lot of, like, this is going to give Ethan a lot of leeway with the judge, is all of their stated intent to provide a substitute to the copyrighted material. Yeah. That is really the big issue here. The fact that they did that is you can argue that, oh, Ethan, you've also violated copyright. Oh, this is all argumentative. Oh, this is all okay. That's fine. It's kind of within his rights to do right now because of what they said. If they had not said those things, this would be it would be a near impossible case in my opinion. But that stated intent to provide a substitute is really what is gonna fuck him.
Yeah, that's the thing he needs to hammer home the most, I think. Number 3. Why is it nobody cares about the Reddit, Ethan? Stop with the Reddit shit.
Not that. He does. He really does.
He's doing it now too with that Fox lady that died. He's trying to he's trying to be mad at her Reddit on their behalf and compare it to his Reddit. Like, he's obsessed with this fucking Reddit thing.
You know, I'm so glad, like, I joined and started posting on Reddit maybe for a couple months before I decided this is stupid and I deleted my account. Have not had one since, could not be happier.
Yeah. Well, here's my thing, right? And I kind of mentioned it with sort of the Fox lady as well. Kind of need more than just saying they talk shit about me on Reddit. Like, they're in their space. Like, yeah, they're constantly talking shit about you, but they're talking shit about you in their own little ecosystem. You need to stop caring so much about
Well,
that.
that's the thing, though. But, well, and here's the thing, though.
Oh, Ava died.
Subreddit worked actively creators to actually, like, to for edit the precedents to. Okay, apparently my thing just had a.
It did. You
had
froze.
a stroke.
Froze and died.
Okay.
You might want to just restart the whole thing. Honestly.
Yeah. So here's the thing. Ethan is alleging that the H3 Snark mods were actively working to organize this group viewing session with the help of the creators, which would go in the way of like just copyright infringement. There's this thing that man's mentioned that's a contributory infringement that I think is kind of a bullshit legal theory. I think that he could have just, if he focused on going after them just for the associated infringement, not this weird contributory thing, he'd have a much stronger case. But the H3 Snark mods, we do know, were actively organizing these group viewing sessions, which were actively being promoted as substitutes for the copyrighted work. So in that manner, there is some relevance for the H3 Snark mods here, but not much.
Yeah. Because it kind of is like, okay, so your complaint is that somebody promoted the, that's basically what it is at the end of the day. It's you're mad that somebody promoted the infringing work. So for that case,
yeah, exactly.
Like, I feel like if I'm defense, I'm like, okay, so why didn't you file a DMCA with YouTube and Twitch? Because they're also technically promoting it by allowing this content to be out there and to be in their algorithm to be spread around. And you haven't done the first step, which is file a DMCA claim.
Well, that's a first step for the natural copyright that's created upon any created work. He registered this this is actually the proper venue for him to do this. He shouldn't DMCA for something that he has registered with the Library of Congress. That's something you go to court for. You don't use the DMCA system here.
I'd figure you'd be expected to do both.
I mean, you should do both. But I don't think him not doing the DMCA system and using YouTube system isn't going to hurt him here, because the copyrighted work is registered with the Library of Congress. Like, that's pretty much a saving grace here. Yes, I agree he should have done the DMCA, but his work to register the work actually kind of like gets past the need to do that.
Apparently Giga is leaving VShojo, according to Mama Oko.
Holy shit!
Well, guess we'll see where that goes.
That was fast. Wasn't, like, Giga was not a part of VShojo for long.
I don't think it's been more than a year.
No, it's not been long at all.
Because if I search just Giga VShojo, I should be able to find, like, her start date.
Giga is an individual who has a lot of corporate experience, and so
2 years.
they come as a VTuber with that kind of like upper level corpo experience, same as I do the VTuber with my law experience. That's kind of their whole gimmick.
She's been 2 years. She joined September of 20.
Yeah,
it's
not
about
very
2
long
years.
for. I mean, I guess that's a decent amount of time. I'm not sure. Okay, Giga joined like a month before Matara. I will say between Giga and Matara, both of them probably had the lowest merch sales out of anybody else in VShojo. And I know VShojo is very much like, hey, this is the one thing you have to do. You have to sell merch. You have to meet these numbers. If you don't, it's a problem.
Do you know why?
And that's part of why Matara was let go. No, it's just their focus, their business model, whatever you would call it.
No, so do you know why specifically those two were lower than everybody else?
Oh, no, why?
So I think it's pretty well known that VShojo does not build talents. VShojo just kind of adopts talents that are already big.
They're like a foster home for already broken talents.
Yeah. So basically
I mean,
everybody
what?
they've had has been big, except Giga and Matara. Both of them were kind of built by VShojo, specifically by the VShojo talent. One of them specifically has a stream where she says that her very first stream performed very well, and people are like, oh, why did it perform very well? It's like, oh, because I was like under the wing of one of the VShojo girls and she was advertising my stream. Like, they were trying, with those two, they were trying to build talents. The thing is, VShojo can't build a talent. VShojo isn't like an organization for that. They don't have the means to do that.
Yeah, they're not built for that.
So they were.
I mean,
it was never going to be a success.
My breakthrough stream was I got 700 subscribers on my first thing, and that was literally just appearing on Gaz Legal Mindsets stream. So like, yeah, if your first stream is that, yeah, you're gonna get a boost.
But it doesn't necessarily carry you all the way.
No, and that's clear by both Giga and yeah, exactly. Them being, separated. Here we go, parting ways.
Yeah.
I do know that Mothra also failed to fulfill some of her obligations. Like,
Mothra was removed because she wasn't doing her job.
Yeah. Yeah.
They said that the final straw was that they had a very important meeting she was supposed to show up to, and she just chose not to.
She completely missed, yeah.
She didn't have an excuse either. She's like, yeah, I just didn't.
She was on stream, and like she was gently reminded by a collab meet like a few times, and then she I think I still have the clip somewhere of her realizing she's missed the meeting, and then her just going fuck it.
Yeah. That's why Madara parted ways. Madara parted ways for multiple reasons. She missed multiple meetings that were considered critical. I believe they said 3 individual meetings that were supposed to be critical meetings.
Yeah, 3 meetings.
She was not fulfilling some of her obligations. And one of the other things, which some people touched on, so VShojo only makes money from the talent's merchandise. Madara had been going around VShojo to get her own merchandise made behind their backs and cutting them out of it. Which for me, that alone would have been enough.
What?
Did you not hear about that part?
Oh, big time. I did not know about that
for
part
me,
at
that
all.
would have been
Holy
enough
shit.
to remove her.
Like everything everything else was enough, right? That's malicious. Oh, wow, Jesus.
I don't know if she just thought it was okay or like what her reasoning was. Because she has currently done so much wrong under VShojo that it could go either way, that she's being malicious or she's just retarded.
I don't think she's being genuinely mean-spirited and malicious. She's intending to do this, but she's really not smart.
Can that make her liable for damages? I mean, not really.
They're not gonna do that. They're just gonna terminate her.
That'd be way too much work to even figure out what the damages are exactly. Or how to calculate them out.
That's kind of crazy to me because as loosely involved as Raging Bull is with my stuff, I would come to him with merch idea.
Yeah.
I would not go behind my company to make merch. What the fuck?
Akko, that's like not hitting your sales quota, but having a side job where you do the same thing. Pretty much.
Yeah, exactly. That's exactly why I'm having a freaking stroke right now, because it makes no goddamn sense.
Yeah, so she's done so much wrong that she's either malicious or she's stupid. I'm fine believing that she's stupid. What is it? It's Occam's razor. Don't attribute to malice that which can be attributed to stupidity. How about we continue this chat? We're not making any progress in this. The moderators of the H3Snark subreddit, the H3Snark mods, knew that Caseytron's group viewing session would serve as an alternative to watching the Nuke on TEI's YouTube channel. Caseytron has a long and well-documented history of copyright infringement. The H3Snark mods were aware of this fact. As such, they successfully
grabbing some water. Keep going.
Caseytron's group viewing session on the H3Snark subreddit. H3Snark is a substitute for the Nuke. Number 4, like most lazy reaction videos, Caseytron's group viewing session of the Nuke is nearly devoid of critical commentary. Instead, Caseytron uses her group viewing session as an opportunity to engage in public degeneracy. So I kind of mentioned this to Ava off stream last time after I read through some of these, because it was our mistake to not read them ahead of time, but they did just drop as we were streaming. I don't think this is gonna help Ethan, and this is already starting where we're gonna see some of Ethan's biggest problem, in my opinion, in these documents, where he doesn't say devoid of commentary, he says devoid of critical commentary, and a lot of his documents are actually directly citing commentary from these 3 girls and trying to debate them on it. And the point he seems to be trying to go for, which is extremely weak and extremely stupid in my opinion, is yes, they did provide commentary, but they're wrong, so it doesn't count. And I don't think that's gonna work well in this type of case. I could be wrong. I don't think it works in his favor. I would have simply not mentioned those things. At least not to the massive degree he mentions them. But he calls her out for public degeneracy, such as continuously smoking copious quantities of cannabis, resulting in Caseytron becoming so obliterated that instead of providing commentary, she stares blankly at her computer. Even more striking, Caseytron peppers her group viewing session with the sounds of loud gastrointestinal emission. Talking about, like, farts and burps. Don't attribute to malice that which can be attributed to stupidity, but even stupidity has a limit is a better quote.
Alright, that was perfect timing. I'm back, and my dad came back with Monster.
Nice. So all I mentioned was right at the top here, Ethan is doing this critical commentary thing. And what I think is the weakest part of all of his documents is that he tries to pull this, yeah, they provide commentary, but they're wrong, and here's a source for why they're wrong, so it doesn't count as commentary. I'm like, I don't think that helps you as much as you think it does. Also, chat says, since chat is bringing up razors, do either you or Ava have a razor philosophy of your own? And they're kind of referring to like Occam's razor, Hanlon's razor type stuff. I probably do, but I would have to sit down and think about it. Because a lot of times my information only comes up when it's relevant, and then it suddenly all comes flooding back into my head. Nerdy texts an accountant for 5. If he could prove they lied on purpose, it might help his case. But it sounds like he's going for that argument. Also, head pats. Because I haven't got a chance to read through Caseytron's yet, so I don't know if it comes up as much in here, because this was the last one he added. But in both Denham's and Frogan's, so much argumentative. And he'll like post sources to it too. He'll be like, actually, the state of Israel is only X percentage Jewish, but she said it was Y percentage Jewish. Here's a link to a CNN article talking about it. And it's like, why? Why are you doing this? Due to Caseytron's highly inebriated state, she watched a long, unadulterated portion of the Nuke for minutes on end. Does he mean unaltered? Would you say unadulterated for that? Is Ava dead?
I guess that's the right word.
I have to double check, because if not, it's gonna like weigh on me. Well,
Alright, just give me a
not
couple seconds
mixed
here.
or diluted, so. Yeah, no, I guess that's technically the right word. It feels weird. Not how I would normally use it, I guess. I don't know. On the rare occasion that Caseytron was coherent, her remarks were brief, surface level, repetitive, and or self-admittedly uninformed. Caseytron's poverty of commentary fails to provide new information, new aesthetics, new insights, or understandings. On the Nuke, the Andy Warhol Foundation for the Visual Arts, Inc. versus Goldsmith Warhol. So he's counting a new case. We're bringing a new case into this. Caseytron's unauthorized, highly commercial exploitation of the Nuke is a quintessential example of copyright infringement. Using copyright content to get attention and avoid the drudgery in working up something fresh. Campbell versus A Cuff Rose Music Incorporated. I would have to read that one. I would never cite any sort of music case in one of these because those are highly restrictive for no reason at all. And they're probably gonna hurt you more than they're gonna help you.
Nightmare.
Lawsuit is to hold Caseytron accountable for her infringement of the Nuke and the H3 Snark mods accountable for their contributory infringement. Whole document seems wordy in the wrong places. I mean, I've read lots of like legal documents. While some stuff feels a bit wordy, I've seen way worse. Jurisdiction and venue. I don't really think this matters all that much. This is just saying, like, this is why we need to sue her in this court, basically. The parties listed. Ethan, Caseytron. The H3 Snark mods consist of does numbers 1 through 10. The true names and exact location of does numbers 1 through 10 are presently unknown to TEI, which therefore sues said doe defendants by such fictitious names and will seek leave to amend this complaint to show their true names and exact locations when the same have been ascertained. Below is a summary of what is known about does number 1 through 6. This I really do not think is going to help Ethan at all. With trying to sue every single H3 Snark mod. Because some of them probably just aren't involved.
Well, at least 10 of them.
Yeah. Doe number 1 is female, the founder of H3 Snark.
I mean, it's not. Reddit, I think, is unaware of how deep discovery can go. If this does go to discovery, Reddit can be subpoenaed for this information, and instantly these guys are all identified and put into lawsuit properly. So,
here's the thing,
this is a genuine.
This is Doe number 1 is the
threat
founder,
for them. Like, they have to understand.
Here, her last post was February 12th. This is kind of what I'm.
Then when did the content nuke come out?
Like a month ago. She hasn't been active for like 4 months before this. This is kind of what I'm talking about. I don't think this is gonna help him. He's just like, yeah, no, she hasn't been active for like 4 months before this, but like I'm still suing her for this.
The content nuke came out 4 months ago. This was all done 4 months ago.
Came out
I'm looking at the right now. Content nuke Son Piker 4 months ago.
There's no way it came out that long ago.
I'm looking at it right now. We all lost the months of time somehow. Look at this. No, I'm freaking out too. Look, 4 months ago. What the fuck?
Why does time move so fast? Also, here it is, chat over to the side. I swear to God, it was like a month ago. Oh, it hurts. Chat, the earth never stops turning, and I hate it. Okay, well, she was active, I guess, probably around the time when it was posted. I'm going to assume she was active after it was posted. It's still weird though that she hasn't posted since then. So that's a little weird. Doe number 2 is female.
That is a little odd, for sure.
Yeah. Wait, aren't they? Okay, so Doe number 1 is the founder, but Doe number 2 is actually the head mod. I was confused for a second there.
Okay, gotcha.
Doe number 2 is female, resides in Canada, and is
how
the
are you
head
gonna
mod.
who resides in Canada? You're gonna have a jurisdictional issue there.
Yeah, that's I don't think Canada's gonna want to. Like, you might be able to like subpoena Reddit for her information, but then you're not gonna be able to do anything with that information.
I would have to see what would even happen there.
I don't think anything.
Because I'm not really sure. Like I have. Yeah, I'm not. I mean, I'm sure, and I don't think she's untouchable, but she's much more of a headache to touch, and so it ends up not being worth it.
Yeah.
But like, I don't know. She might be as close to untouchable as you can get.
Doe number 2 currently uses the following Reddit usernames: H3 Snark Mod Team 2, Roman P, Right Salamander. Previously, Doe number 2 used the following Reddit usernames, which were either deleted or suspended by Reddit for violating its content policy: CavCav2, Narcomod Team 3, Wrong Salamander, Right Salamander with 2 R's, Pure Press, Kitchen Mukbang Star. On Discord, Doe number 2 uses the screen names Sally and Ali Turn.
I'm sorry, but Kitchen Mukbang Star is such a wild freaking... Look at how many deleted, suspended.
Yeah, I wouldn't doubt that Doe number 2 is probably the biggest problem in this area, because everybody else looks like they have small things going on. Like, Doe number 3 began as a user of H3 Snark and was subsequently made a mod. Initially, Doe number 3 used the Reddit username Sarah Horn Jewitz.
Oh shit, no, here's what's gonna happen, guys. Donald Trump is gonna make Canada the 51st state, and then Ethan can sue him. I heard it.
She subsequently deleted the Sarah Horn Jewitz account and used the new Reddit username Jewitz Sarah Horn. Doe number 4's account name on Discord is Rose Waylandham. Doe number 5 is male and goes by the name Tony. Doe number 5 was made an H3 Snark mod. His account name on Discord is Frampu. These two are kind of throwing me off, right? Because they're saying this is all the H3 Snark mods. They only mention Discord name. And I think once you're kind of looping around different accounts like that, where the infringement didn't necessarily happen, you're gonna run into problem.
Well, this is just as identifying information as they can for the purposes of getting this complaint through to discovery. It's then through discovery that a lot of this information will actually come out and come Doe 1 through 10 to their actual names and everything like that. But this is just him providing what identifying information he can for the purposes of getting through to discovery.
This is the warning I would probably provide. And this isn't necessarily a legal warning, obviously, because this is... Like, I saw some people trying to say this was a problem. No, this is totally legal in court. I don't know why people thought it wasn't. Granted, it was a small number of people, but it's completely legal to, like, find people's stuff through discovery. That's kind of the point of discovery. I don't know why people thought it was illegal. However, it speaks to the fact that so many people think it's illegal, how people view it, like, from an optics perspective. So the warning I would provide to Ethan is if it comes...
here's the big thing.
Yeah.
Right, because Ethan would he found it in California Federal District Court, but still, California defines doxing as the publication or republication of uniquely identifying information, private or public, to a new audience with intent to cause harm. So what this means is that even if you were to, say, use the courts to obtain these people's information, right? That's entirely fine. Publicizing it yourself would be the act of doxing.
Yeah, because I would warn Ethan that if you do find this information through discovery, and like the court doesn't kind of allow it, you can't just go around publishing it. Specifically in California. I know in other places they kind of define doxing as only private information, so it wouldn't necessarily be
Frogan
legal there.
and Denims especially would be protected from any kind of attempt from republication of their name by Ethan through these court documents. Like, Ethan would definitely get in trouble if he were to do that.
Yeah. So that's my warning from like a legal perspective. From like a regular perspective, you don't want to draw attention to their real life names because people are going to look at you negatively.
Scummy.
Just from like an optics perspective. Yeah. And that's future Ethan problems. But if you like go around like, hey guys, check out my court case, and it's like they found out that you doxed all these people. Well, I mean, doxed through discovery. It doesn't matter that it's legal or that it was necessary. People are going to look at it negatively. They already are in some cases. So just, try not to...
Yeah, I love a lot of people are still going with the entrapment. Oh, Ethan, this won't survive because he intentionally entrapped them. No.
Entrapment's for
just
police.
Because he knew someone was going to steal from him doesn't mean that installing a burglar alarm was illegal.
People misunderstand, like, some laws are for us and some laws are for, like, the government. Like, entrapment is for police. Police can't trick you into it. Doesn't really say anything about, like, a regular citizen. And it's kind of the same thing with free speech.
Yeah, and here's the thing, you still did commit a violation. They might have tricked you into committing the violation, but you were the one who was dumb enough to decide to look at this and go, I'm going to break the law. So, again, personal responsibility does come into play here.
I'm learning much watching this, how complex lawyering can get. I am glad we are teaching the chat something. Because I was going to say this at the start of the stream, but when I asked Ava to do this, what I thought we were going to do is we were going to just watch really funny court videos and use the fact that we know a bit about law to also talk about it, but mostly watch funny court videos. And then literally one stream in, it's like, okay, well, let's analyze this court case.
I mean, it's a good one to actually, like, go through at least.
Well, I mean, and I'm glad that people have stayed for it. People do seem to enjoy us just analyzing it, even though there's not, like, a whole bunch of super exciting court drama happening. But, chat, legal stuff gets confusing. And it's something you do have to consider in lawsuits. Like, how much money am I going to have to spend doing this? Because if you're going to spend more money than you're going to get back, for some people, it's just not worth it.
Multiple months, if not years, to spend on dealing with this and the heightened, elevated mental stress that comes with just being a part of active litigation. There's a lot of, like, a lawyer will often tell you that their goal is to get out of court settlements or to solve things without putting it in front of a judge. If it ends up getting to a lawsuit, we have in some way failed. Now we get to play play the rebound and win the court case, sure, and like win at trial, great. But like honestly, a lawyer's only winning if they get you what you need without having to put it in front of a judge in the form of a lawsuit.
Pretty much, yeah.
So we're talking settlements and stuff like that.
I don't think he'll go for a settlement. I think Ethan wants the case to go forward. Like, obviously, he'll have to come to the table and come up with, like, an excuse for why he's not going to.
No, he would want a settlement, but I think his demands for the settlement would be so ridiculous and over the top that, like, they wouldn't go with it. You know what I mean?
Yeah,
like, they would come to the table and Ethan will demand the world. He'll probably demand, like, a public apology, lock them in the stockades and throw tomatoes at them, like, shit that you can't even do anymore. He want done in contrition.
Lawtism just can't chat because I'm doing deliveries. Have fun with your deliveries. It's okay. Like having you here is enough. We love you. I'm making a little heart shape with my hands. You can't see it because I don't have arms that move. But yeah, no, it's kind of like, I feel like how he would do is the same way, like when a judge issues like $1 million bond. Like, yeah, technically they have that, but we all know the point is so they can't meet the bar. But factual allegations, background of TEI, this is just explaining that he does highly stylized reaction videos with relatively short segments of the original video, long segments of commentary. After TEI was established, the Kleins assigned both channels to TEI. 2016, the Kleins were sued for copyright infringement, defamation, and misrepresentation by Matt Hosendaya. Was that really only in 2016? I guess that is a long... God, that's 10 years ago. Jesus fuck. I'm old. So old. You got legs, Mizu. Don't tell us you lost your arms in the exchange. I mean, I have arms. They just don't go up. The copyright claim concerned a reaction video uploaded to their Ethan and Gila YouTube channel. The video, entitled The Big, the Bold, the Beautiful, was critical and humorous reaction to Matt Haas's video Bold Guy versus Parkour Girl. As the court in Hosendaya explained, the Klein video opens with commentary and discussion between Ethan and Gila Klein, followed by segments of the Haas video, which they play, stop, and continue to comment on and criticize. The Klein video, which is almost 14 minutes long, intersperses relatively short segments of the Haas video with long segments of Klein's commentary, ultimately using 3 minutes and 15 seconds of the 5-minute, 24-second long Haas video. The Klein video is harshly critical of the Haas video. It includes mockery of Matt Haas's performance and what the Kleins consider unrealistic dialogue and plot lines. In addition, defendant's commentary refers to the Haas video as quasi-pornographic and reminiscent of a cringe-tube genre of YouTube known for cringe-worthy sexual content. As critical as it is, the Klein video is roughly equivalent to the kind of commentary and criticism of a creative work that might occur in a film studies class. I will say, part of what I think is going to make it difficult for them to compare the two cases is this was during a time when videos were much shorter on YouTube. Like, you can see it now. We only use 3 minutes of a 5-minute video in our 15-minute response. And now we're talking about they use the full 1 hour, 30 minutes in their 7-hour response. Like, I'm not saying like it necessarily changes the case. I do think it makes it harder to just make one-to-one comparisons. And there's gonna be a lot more discussion that needs to go on. On August 23rd, 2017, the court granted summary judgment for the Kleins on all of Matt Haas's claims. Hosendaya for the copyright infringement. The court found the Klein video made a fair use of the Haas video. 2017, TEI established the H3 podcast on YouTube. On the new channel, TEI produced podcast episodes that were less structured than the reaction videos the Kleins previously made. To ensure any use of unlicensed copyright content qualified as fair use, TEI formulated and refined best practices based on the principles from Hosendaya, which included 1. Whenever feasible, pre-screening the original work and outlining the criticism and commentary before the broadcast. 2. Ensuring the commentary was directly related to the style and/or substance of the original work. 3. Only broadcasting the portion of the original work that would be subject to critique. 4. Pausing the original work frequently to provide critique. And 5. Ensuring that the duration of the commentary was substantially longer than the previous portion of the original work show immediately before the commentary. I understand that these are their version of best practices. Some of these I don't think are gonna, like, work well as arguments. Like, specifically the pre-screening the original work, especially when you add whenever feasible. Like, when is it not realistically, when is it not feasible to pre-screen it? Ensuring the commentary was directly related to the style and or substance of the work. I mean, yeah, that's kind of duh. Number 3, I don't think is actually applicable to them. Like, they claim this, but are they just gonna admit that every single time they just play the whole video, the whole thing was the portion they wanted to cover? It's just not a fantastic argument given their own track record. Number 4 is good. Pause to provide critique. And number 5 I don't think is something you strive for. It's just something that naturally happens if you're actually providing critique. Because if you watch a 5-minute video and your critique of it's shorter than 5 minutes, I don't think you really commented on the whole video. I've seen React videos with that much of a ratio of original.
Well, that's what the courts always end up having to, like, determine. Like, how much commentary, how much additional commentary on the content equals enough to be fair use. That's what every judge in every court in every individual case has to come to the conclusion of.
Yeah. Caseytron flame bait fixture. What is this? This is your facts section. Please tell me that's something she calls herself and not a name you invented for her. Caseytron has been streaming for
I don't even know what that means.
Yeah, neither do I. Caseytron has been streaming for over a decade. She's amassed
over a decade, wow.
Yeah, amassed over 540,000 followers on Twitch, her streaming platform of choice. Caseytron is not known for her intellectual acumen or analytical prowess. That might be a little bit over the line. That's just kind of insulting at that point.
It's not. That's normal lawyer shade. It's shade. Look, this kind of shade is like the name of the game when it comes to writing these kinds of complaints. So,
you know,
like, I see no problem yet.
And it just hit me now, because this actually has come up in previous copyright cases. Caseytron streams only on Twitch, and Ethan only does the podcast on YouTube. And some courts do consider change of venue.
Oh, that makes it a stronger case.
Well, some courts
that makes it a stronger case for Ethan, though.
Some courts consider change of venue weaker for copyright. Because if you provide a substitute to another platform,
a different audience.
The only time I've seen judges consider it stronger is when it's a paid-for
boil
platform.
Down to providing a substitute. If you, a paid-for platform, that makes sense. But I don't know. I could see taking his copyrighted work, substituting for it, and actually publishing it on a platform he doesn't actually normally do. That's a whole nother audience of people that you are getting from and profiting from his work in a way that you should be. I would say that is actually a stronger case for Ethan, but that's just me.
See, that's the thing. It sounds like it would be.
Because again,
but
this
judges
is
have
yeah,
routinely
it's down
decided
to
it's
judge
not. Because, and this happened like with the Sargon case as well. They seem to believe that. Do you honestly believe that Twitch argument would have gone to YouTube just to watch a video? And they'd be like, they wouldn't. That means it is a completely different audience. Therefore, they did not actually take anything from you. Because you would not have had it either way. Despite desperately wanting to be taken seriously by the alt-left online commentary community.
Oh my god. There's so much fucking shade.
Caseytron's claim to fame
this is still not as much shade as I've seen in other complaints, but it's pretty bad.
Caseytron's claim to fame is her public acts of degeneracy and brazen acts of copyright infringement. Caseytron streams compromise of her watching unlicensed third-party content while smoking copious quantities of cannabis and impersonating, albeit unintentionally, the cartoon characters Beavis and Butthead. Sometimes Caseytron is not even conscious while streaming unlicensed third-party content. The most infamous example occurred June 2023, during one of Caseytron's subathons, streaming marathon to acquire more paying subscribers. During the subathon, Caseytron streamed entire episodes of the television show Kitchen Nightmares while passed out from her overzealous consumption of cannabis. On June 25th, 2023, Caseytron was temporarily banned by Twitch due to her chronic copyright infringement. When the ban became public, Caseytron posted the following on X, and I'll do it again, original spelling. This is more of an argument for why Twitch is a problem, not necessarily Caseytron, I'll be honest. Like, she is obviously a problem.
Well, this is still Caseytron's problem. Yeah, this is her actions, yeah. Twitch as a platform is not properly or appropriately moderated, but this is still Caseytron's actions.
Background of H3 Snark. H3 Snark is part of a genre of message boards known as subreddits. That's not what I would call it. By the way, thank you, chat, for the
on the website Reddit.
Reddit Snark.
He just phrased that sentence really weird.
Yeah. I also wouldn't really call them like a genre of message board. I would have just said H3 Snark is a message board on the website Reddit. Like, I don't know why you need to word it this way. Snark subreddits comprise of, quote, fallen fans of a particular entertainer. Over time, there have been numerous Snark subreddits regarding TEI's podcast and of the Kleins. Many were banned by Reddit for violating its content policy, such as Our Frenemies and Our Frenemies 2. H3 Snark was created August 30th, 2023 by Doe Number 1, who is a fictional Trisha Paytas fan. Sorry, fanatical Trisha Paytas fan. Doe Number 1 became a fallen fan when the TEI series Frenemies, which was co-hosted by Ethan and Trisha, ended abruptly in June of 2021. H3 Snark became a haven for fallen fans.
So wait, real quick, just a question that I have.
Yeah.
Why did it end abruptly? I mean, hey, this is just like, if we're gonna cover it in this complaint, why did it end so abruptly?
Is that a genuine question, or are you just like for the funnies for the lawsuit thing?
It is a question.
So,
but
the genuine answer...
He's someone that, you don't have to...
Well, the genuine answer is that Ethan uses people in order to try and get ahead. This is not the first time he has used somebody that very clearly has mental problems in order to basically boost his own station. Which is one of the reasons why so many people don't like Ethan Klein.
Yeah.
Like, he'll find people that have issues, and he'll be like, hey, you should come on my show, and we'll make you famous, and we'll make you money. And then he'll just basically use them as, like, basically bum fights, but on YouTube.
So he Nick Rickettas.
It's been a huge point of criticism for Ethan for a while. Like the drunk old guy? Yeah, like the drunk old guy. Because it's very clear that Ethan does not want to help these people, and he doesn't want to get them help.
Wait, he brought an old drunk guy on his podcast?
Yeah, it is a guy that clearly has, like, severe mental problems. And everybody's like, no, Ethan...
dude, you can't...
People told him before he did it, after he offered it, people were like, Ethan, don't do it. Like, don't.
Yeah.
And he just wouldn't listen. He's like, no, it'll be great content.
It. Yeah. Well, I mean, I keep hearing, I think I've heard it from you and Oko both, that he has a button that will just delete, like, the last 30 seconds of what he said on stream.
Yeah. He paid, like an obscene amount of money for the button.
That often that he can just push a button. It's like, oh, shit. Retraction.
That button cost him, like, 5 figures. Funny.
How the fuck did it cost him 5 figures? What the hell?
That's what confused it. Like, he's said it before that it's like the professional button, like the news quotes use. 15,000 is the price I heard. That's what I heard as well.
That's so I'm gonna throw up everywhere.
I'm like, what do you mean it costs 15,000? What do you mean I can't, like, get some fucking...
Dude, this is a button you could freaking press to a certain freaking OBS fucking thing or something. Yeah. Like, this is relatively easy. I could do it for maybe $30.
Yeah, I don't understand where the money comes from. But yeah, no, this is not necessarily relevant to the case.
It seems like an unnecessary flex. Like, hey, I wasted all this money.
Yeah. Like, this is not necessarily relevant to the case, but it might end up becoming a question if he really pushes this H3 Snark thing. where they come up and they're like, yes, I have extreme moral opposition to Ethan's content. Because then he has... Because here's the thing where it's not helping him, where I kind of have to reference that previous Sargon court case about copyright infringement, where the judge basically said, look, the difference in fan base is so severe that I can't in good faith find copyright infringement because they physically would have never watched your content to start with, because they have such moral opposition to you. And I think that could end up happening here, where he's like, yeah, these people have a severe moral opposition to me, and all of them have this moral opposition. By the way, they also all stole my content by watching it somewhere else. I'd be like, maybe that works in this case because the Sargon case wasn't precedent setting. Maybe it doesn't. At least I don't think the Sargon case was precedent setting. I'd have to double check. I'm pretty sure it wasn't, or we'd probably hear it quoted more often. H3Snark became a haven for fallen fans. While the average viewer would move on with their lives after becoming disinterested in a podcast, H3Snark fallen fans religiously watched TEI produce contact with... I'm sorry, I can't read that word. Orgiastic? I've honestly never seen that one, chat, and I consider myself a fairly well-read person.
Wait, let's repeat that.
Orgiastic. ORGIASTIC.
I'm not gonna lie, I'd have to pull from the freaking thesaurus for that one.
I've genuinely, chat, I'm sorry if I'm saying that wrong. I've never seen that word before, ever in my entire life.
Orgasmic. It's now orgasmic. We're changing it.
It's orgasmic.
Yeah, it's orgasmic.
H3Snark enables these deranged and chronically unemployed fallen fans to share their perverse pleasure of hate-watching TEI content with others by providing infringing clips and links to TEI content. I don't think that argument is going to work at all, because that's the nature of Reddit, and I think he would have to go more for Reddit than the subreddit for that.
Well, remember, this is all like he's describing the platforms that these individuals are using, but the platforms themselves cannot be held accountable due to safe harbor protections.
Yeah, but I would think that would apply to the people as well, not the people committing the infringement, right? Because he's not.
Oh, okay.
But that's the thing. He's not accusing them of committing the infringement. He's accusing them of allowing other people on the platform to commit infringement.
No, he is accusing them. He's accusing them of contributory infringement, which might be, in my opinion, a weird-ass legal theory.
That's what he says here.
He is accusing
they
them of
enable deranged and chronically unemployed fallen fans to share their perverse pleasure of hate-watching by providing infringing clips and links.
Okay, did you say infringing clips? How is a clip infringing?
It says providing infringing clips.
How's a clip? A clip I know, but that's what I mean. That's what, this seems to be some very pointed language that I have a problem with, because a clip in and of itself is transformative in nature. It's a fucking clip taken from a larger piece of work. So how the hell can a clip be an infringing?
Yeah. Also, really quick, I'm gonna search this because people are now mentioning it and I have to know. Why would you use that word? What?
What is the word? What does it mean? Because I really don't know.
Orgiastic, of, relating to, or characteristic of an orgy.
Are you kidding me right now?
What the? It was
okay. So
that's from Merriam-Webster.
I made a mistake. I made a joke. I made a joke saying, "Oh, we should just call it orgasm," but that's far more relevant than I fucking ever would have thought. Orgiastic hatred. Wow. Okay. Whatever.
I wouldn't have used that word, but okay.
Yeah, that's
weird choice of word. Might as well have just said orgasmic. Beginning in the fall.
Yeah, orgasmic hatred would almost make more sense.
And people would actually know what the word is.
Oh, so you're saying he got a hate boner? Exactly.
Beginning of the fall of 2023, H3Snark experienced a surge of new users who were fallen fans of the TEI series Leftovers. The show was co-hosted by Ethan, the most prominent all-flesh streamer on the website, which... Oh, and the most prominent. I was about to say you worded that weird, but no, it's fine.
Yeah, it's fine.
Hassan Piker on September
Hassan Piker!
I'm coming to kill you!
I just have free time. I hear his voice.
Everywhere I look, I see his face.
Yeah, it's Sam Hyde looking into the camera going, I'm gonna kill you! In the ring, right? No, in real life. Oh, shit.
On September 14th, 2023, Ethan and Hassan debated various issues concerning China and Taiwan, such as whether Taiwan should be independent, the property of China's subjugation of Tibet, the genocide of the Uyghurs. Due to Ethan pushing back on Hassan's pro-China positions, several Leftover fans who had been ecclesiastical parasocial relationship with Hassan flocked to H3Snark because they felt Ethan was critiquing them personally. I mean, you kind of were, to be fair, but... The surge of new users to
you were actually critiquing them personally, which is fine. But, like,
Just
don't act like it wasn't happening. Yeah, it was happening. It's okay.
The surge of new users to H3Snark exploded after October 7th, 2023. The Kleins are dual Israeli-American citizens. Hila was born and raised in Israel, where she served as a secretary during her mandatory conscription into the Israeli Defense Forces. While both Ethan and Hila are highly supportive of Palestinian self-determination and extremely critical of the Israel and its government, the Kleins support a two-state solution as the best interim solution to the conflict. In the way,
this is...
this is where you start getting to the point where he starts debating them. And, like, debating their politics.
This is the part. Well, I was wondering how badly he was gonna do it with Caseytron's document, but here we are.
Yeah, like, we're only 10 pages in, chat.
Yeah, and this is where we start to go, okay, this is stuff that you could trim out. You could trim out a lot of fat in this complaint, and it would be a far stronger one for it.
And then look, chat, almost half of this page is just sources. Maybe not half, maybe like a third of the page. Some of it is relevant sources to, like, his podcast. But then he's got stuff like World War II, the Nazi Islam Alliance, World War II biography special.
Why did the Grand Mufti of Palestine collaborate with Nazi? Why is this happening? Why is this here?
This is the slow decline, chat. I haven't read through this one yet like I did the other two. I'm assuming that it's the same as the other two, where this is where we hit the slow decline of, I need to debate them.
I mean, this is... I mean, this is his time to own these guys, and you know... Beyond this, I don't expect to see the filings have all of this irrelevant information in them, but, like, if there was ever a time to put this kind of, like... Because you're airing out all your grievances... Yeah. If there was ever a time to put this stupid bullshit in, it would be in this particular initial document. If you're gonna do it. I personally wouldn't do it.
This is what it's sourcing to. In the wake of October 7th, Hassan emerged as the modern incarnation of the Grand Mufti Hajj Amin al-Husseini. That's what the source is for.
I'm sorry, fucking what?
So for some reason, they included this source to, like, source their insult for Hassan.
But here's a problem. Look, in the wake of October 7th, Hassan emerged as the modern incarnate. I'm sorry, are we dealing with freaking reincarnation right now? What the fuck is happening?
Yeah, he's basically insulting Hassan, and then he's sourcing his insult because he knows people won't understand what he's trying to say.
Look, Comedy 101. You cannot explain your joke, even in even a legal filing. You should not have to explain your joke. Shit, but you are.
This is meant to be played in court. Not necessarily, no. However, if I am the opposing counsel and this does go to jury, I am reading this entire fucking thing to the jury. Because it makes Ethan look that bad. And the jury's gonna be like, yeah, so... Jesus.
It does make him look really petty and weird.
So, jury, for what you guys showed up here today, this one page is relevant information. Here, if you want that, you can look over that. Now we're going to go over the 50 other pages of his filing, which are completely irrelevant bullshit. And it's just him insulting my clients repeatedly.
Yeah. Here's the proof that they provided by...
Oh my god.
By the way, everybody.
Look at this. This is the entire page
talking
here.
About Nazis and Zionists, Jesus Christ. Yeah, okay, now this is like 2/3 of the page. It's just sources. Look at that, wow. Holy crap.
This is what I was... people are like trying to mess with me on Twitter chat when I said that his filings were horrendous. And they're like, oh, you're just defending Caseytron and them. No, I'm not defending them. This is just retarded.
They're a little extra. They're definitely a little extra. But again, this is pretty, like, I will say there's a lot more debate about Israel and Palestine in sources to such than most that I've read. But, like, in terms of, like, the shade throwing, the intellectual digs, and like, this is pretty normal. Like, it's getting to be a little much, but it's still pretty damn normal.
Sorry, just to go back up here so I get the first part. Like Al-Husseini.
But this is also in line with a problem I have with a lot of lawyers and their filings. They just have too much extra stuff. And I know it's probably Ethan who insisted that this information be included.
I hope it was Ethan
and the lawyers just doing their
included.
job.
If I found out the lawyer thought this was a great idea, I would be so upset.
Yeah. No, I feel like this is all like Ethan insisted that this be included in my brief. My complaint would probably be 13 to 20 pages.
Yeah.
Probably at most.
If I found out that his lawyer was the one that insisted on all this sourcing bullshit, I'm going out tomorrow and getting my bar.
Yeah.
Be like, oh, any idiot can do this shit. I'll go get it now. Oh. He said, like Al-Husseini.
I just saw Joe Biden.
Yeah, he sources Joe Biden.
Just keep scrolling. I just saw that. I'm like, what the fuck? Where are we right now?
Like Al-Husseini, Hassan is a passionate advocate and highly charismatic leader of the Palestinian cause. Remember, chat, Hassan is not being sued anywhere in this, so we're now debating Hassan for some reason. Like Al-Husseini, Hassan used his massive platform to spread genocidal rhetoric about anyone advocating for the right of Jewish self-determination in their ancestral homeland.
So fucking wild.
The primary difference between Hassan and Al-Husseini is that Al-Husseini has worked with the Nazis and advocated the annihilation of Jews, while Hassan advocates the annihilation of all Zionists. Since the vast majority of Jews in the United States say caring about Israel is essential or important, this would necessarily include the vast majority of Jews. And then he gives a billion sources for this.
I'm taking so much psychic damage right now. I'm taking so much fucking psychic damage.
There's like just so many random sources in here now. This one just says Germany. Was there like a second part up here? Oh yeah, this is the second part of this Nazi quote. So the Nazi quote doesn't end until here. This is all a part of the source for the Grand Mufti comment. Goes all the way down to here, and we've got 2, 3, 4 YouTube sources, 2 encyclopedia sources, and then 1 Wikipedia source. And this was supposed to be a joke jab at Hassan, who's not even listed in this as like a party at all. You had to paste 6 sources for your fucking joke, dude. Calm down. Source number 12, A History of the First Arab-Israeli War from Yale. Source number 13, Philip Matar, the Mufti of Jerusalem and the Palestinian National Movement and Zionism from Britannica.
We don't... Oh, God, what is this?
Number 14, Nazi Propaganda for the Arab World from Yale.
Nice.
Anti-Semitism from Nazism to Islamic
a
jihad.
Of evil. God damn.
What are these papers? Also,
how U.S. troops are experiencing the Israel-Hamas war.
Thank you for the head pat, Blue Sky. It's much appreciated.
Oh, thank you so much. There we go. Head
City Sorts Pew Research. How U.S. Jews are experiencing the Israel-Hamas war. And then U.S. Jews have widely differing views.
Yeah, you know
Israel.
how many airstrikes these American Jews have managed to duck? You know, it's pretty bad.
What? Why is this in your exhibits? What?
Hey,
why are you so dedicated to this fucking joke about calling Hassan the Grand Mufti or Al Hassini or whatever the fuck he is?
Bro, this is as close to Godwin's law as I can think somebody getting without actually, like, crossing the line.
Guys, look. It's Hassan.
Yeah, you're not calling Hassan... Look, he's not calling Hassan Hitler. He's just calling Hassan... Hitler's friend. Yeah, the friend of Hitler. Yeah, it's so fucking... This is so weird. This is so fucking weird.
This is a court filing for copyright about fucking Caseytron. And we're comparing Hassan to Hitler with pictures of Hitler. Oh, it keeps knocking it down. I want it to stay up here.
You know, that actually reminds me of, we were talking earlier, one of Caseytron's statements in the very beginning. It said, what's even going on? I think I've lost the plot. And during that part, I think it was like a clip of Hitler, and there's a play where you go, Ethan, is this like, why is this relevant? And all to the point you're trying to make.
Is he trolling the court? So me and Ava talked about this last time. We definitely think he wants this to be a public spectacle. Trolling the court, maybe not necessarily, because he did go to a real lawyer. But he does want it to be a spectacle.
I do feel kind of in that way, yeah.
Fucking Al Hassini with his close friend Heinrich Himmler. 1943. I don't understand why he...
Oh my god, I'm a Dojin.
Thank you for the Dojin character, chat. I'd want justice in my court time, but what do I know? Wait, what was the top of this quote? Since the vast majority of Jews in the United States say caring about Israel is essential or important, this would necessarily include the vast majority of Jews, even if they support... Wait. The Palestinian cause and vehemently condemn the actions of the Israeli government. That is... I really don't like that they formatted it that way.
No, we need to skip, but like, this is starting to get irrelevant enough that I'm like, okay, now we're gonna get into skim mode here.
Yeah.
Because it's getting really bad.
Arabs rise as one man and fight for your
And then when you just have, like,
sacred...
pictures of Hitler and some other guy from 1941 and you're freaking complain, in 2025, you're doing something wrong.
Now he's just putting quotes from Al Hassini in here. I'm not reading that chat because I'm probably going to get in trouble if I do. Somebody's going to take that out of context and get in a lot of trouble. Mama Akko for 5. I need to know why this stuff was used in his lawsuit and why Saul Goodman convinced him the head pats would work. And Blue Sky says, I mean, we have no proof he isn't friends with Hitler. On October 12th, 2023, the last episode of Leftovers aired. It was comprised of a discussion between Ethan and Hassan regarding the Israel-Palestine conflict and the events of October 7th. During the discussion, Ethan expressed his support of the Palestinian cause and empathy for their suffering, along with condemning Israeli Prime Minister... Is that really how you say his name? I always thought it was Benjamin. Is it actually Benjamin? I've always heard it said Benjamin.
I guess. I thought it was Benjamin, but that's Benjamin. I'm
gonna assume that's correct. And I've just been saying it wrong the whole time. Besides, the only part that matters is the ending, Netanyahu, because it sounds very funny. Benjamin Netanyahu. At the same time, Ethan attempted to humanize the victims of October 7th to Hassan in the hopes that empathy and mutual understanding could begin to heal the divide. Hassan was unpersuaded, and the relationship with Ethan and Hassan began to deteriorate. Okay, I sort of see where he's going with this now. He's trying to, like, this is his factual basis section. He's trying to say this is why they ended up being so malicious to him, is because of the falling out with Hassan.
That's probably.
That's the best I can do.
But who cares?
But yeah, because it's like a factual thing, right? It's like, okay, who cares about why they were malicious? They said they were malicious. Like, you've got them
were malicious.
on
yeah,
recording.
Exactly. Focus on, yeah, you have the exactly. You have them dead to rights. A lot of this is unneeded, in my opinion.
In the aftermath of the falling out between Ethan and Hassan, H3 Snark became a radioactive hub of fallen fans of TEI content, and the Klein became a focal point for spreading vicious lies and outlandish conspiracy theories and hallucinatory misrepresentation. Oh, here we go. The rampant copyright infringement on H3 Snark. Despite their hatred towards the Klein, the users of H3 Snark had an insatiable appetite for TEI's content. The H3 Snark users, however, did not want TEI to receive any views or advertising revenue from their consumption of TEI's content. As a result, H3 Snark became a locus of copyright infringement of TE content as detailed below. One method of the mods used to employ or to consume TEI content was to share links of TEI content on YouTube. What? Is there actually a website called YouTube with an EW?
There's a website called YouTube.
It's pretty
with
close,
JE right here. It's a talent management and discovery website, but YouTube is a thing.
Oh, fair. A website that provides unauthorized access to YouTube videos and publicly performs them, which constitutes copyright infringement.
Go after YouTube then. I mean WEW.
Yeah.
Or YEW YouTube.
There's
like
that.
They're the one providing the unauthorized access that allows this infringement to even occur.
Yeah, there's that. And would you then argue that if they went to watch your videos but they had a copyright blocker, that they were also infringing on your video? Like, not the copyright blocker, but them, not copyright, the ad blocker.
Ad blocker?
Yeah, sorry.
Probably not. Probably not. I don't see that being, I mean, unless it's mentioned here, I don't think he would cross that line. That's a pretty solid one. Like, an ad blocker, that's YouTube's war. That's not my war.
Yeah. YouTube had particular appeal to H3 Snark mods and H3 Snark users because a video watched on YouTube does not result in a view or advertising revenue to the original on YouTube.
Oh.
H3 Snark mods conducted live chats when TEI content was broadcast live. During the live chats, the H3 Snark mods would spam the chat with YouTube links of the broadcast. Once the live stream ended, the H3 Snark mods concealed the evidence of their copyright infringement by deleting the live chat logs. Below are true and correct screenshots of the H3 Snark mods spamming the live chat with YouTube links to the TEI copyrighted content. What I'm going to say, chat, is actually kind of interesting, is that this, for me, is a lot more damning for the H3 Snark mods. It's not mentioned anywhere in the first two lawsuits. I don't know why it's just now being brought up. As far as I remember, it's not.
Oh, that's right, because you covered the first two lawsuits. That's right.
Yeah. As far as I remember from what I read, this is not included anywhere in the first two.
This is interesting.
This would change my opinion on.
I mean, this is pretty good. Yeah. No, yeah, because I mean, this is a clear pattern of like active malicious infringement.
Yeah.
Like they're going through a lot of effort here to make sure that you guys don't get these views. Like that's actually fucking insane.
Oh, Simon,
but now it does raise the question, why was this not included with the other two complaints?
I'll put it in chat. So, Symes, it's not YouTube, it's YEW. It's supposedly like some secondary platform. Which also would have
safe harbor protections, but if they are themselves breaking the law in how they host the content, that's going to waive any safe harbor protections they might have.
Yeah. Which
YouTube is being described as a website that unauthorized accesses YouTube's system, and does it provide any views or analytics to people who view using those links? That is a clear. I'm pretty sure that's a violation of several laws, and YouTube, the tree YouTube, will not be able to benefit from safe harbor protections.
Yeah. So here, yeah, it's pictures of them providing the links for it. Maybe he just didn't have it when he filed the first two.
Maybe that's it, but I will say this goes a long way into like, wow, this is pretty bad.
Yeah. These people aren't competent enough to give a good defense. I mean, they're gonna have a lawyer. Like, they make a lot of money.
Oh, and Denim's apparently isn't. She still hasn't gotten a lawyer. She's just not shutting the fuck up. She's trying to say, oh, Ethan's only suing me because I'm a woman.
Yeah.
Bitch, fuck you.
To be fair, we talked about this last time, if it goes to jury trial, guarantee the lawyer at some point is going to bring up. So all of these,
they are the
he has this huge list of men and women, but he chose to only sue 3 women. And Denim's case is in California.
Well, I'm not just suing these 3 women. I'm also suing these 10 individuals, some of which are male and female.
Actually, the only ones he mentioned genders for were women.
Wasn't there a male in the Smart Mod number 67?
There might be, but in the factual basis above this where he mentions the Snark mods, the only time he mentions gender is when they're female.
They mentioned mostly mod 1 and 2, both of which are female.
So, I mean, I'm not saying it's a good argument, chat, but if he gets a jury trial in fucking California, yeah, as the defense, I'm bringing up that every single named gender is female. Because, I mean, that's just how California is. I guarantee, depending on where you are in California, jury's going to be sympathetic to that.
Again, I think he's just asking for summary judgment just so he can... I mean, he's asking for a jury trial just so he can retain one if he wants, because if he doesn't get one in the start, he can't have one later.
Yeah. Ike says, "Holy guacamole, caught the elf live." Look at that. You got people chasing you around, Ava.
I keep running, but they keep fighting me.
Through various comments to post, Doe number 3, Sarah Horn-Jewitz, encouraged H3 Snark users to use YouTube as an alternative to watching TEI's video on its official channel. Doe number 3's comments were later wiped due to Doe number 3's efforts to use... The user was anointed as one of the H3 Snark mods. Some examples are contained below. August 24th, the U Pearl Unicorn created the post. For those who wonder why snarkers watch, moments like the second button failure. I think you put the comma in the wrong space there, or maybe they did. Now, for those who wonder why snarkers, what moments like the second button failure? Below is a
that feels like an improperly put comment.
It threw me off.
Comma.
Sorry. Are we doing the repos at the same time as always? Yes, we were doing repo tonight, which, by the way, Ava, you are free to join repo if you would like. As always.
I would love to. I don't know if I'm going to be able to, but I'm going to try.
Understandable. We encourage folks to watch on YouTube since it doesn't play ads or contribute to their view counts. As can be noted, Doe number 3's comment was subsequently wiped from the August 2024 post. And here it is, Sarah Horn-Jewitz. We encourage folks to watch on YouTube since it doesn't play ads or contribute to the Megathread, the H3 show.
That's a smoking gun right there.
For this person, yeah. I think a big problem he's going to encounter is he talks about them as a monolith. And even if they are all on a team together, because of the nature of Reddit comments, there's going to be a lot of gray area of who knew what. And he's going to have to... If he's going to try and put them all together in one big lump, he's going to have to try and be like, okay, all of these people know. Which, to be fair, I do think they all know. That's going to be harder to
prove, but if he has enough of a pattern behavior, he might be able to do it.
Yeah.
Because all I'm seeing here, and like, this one's better than the other two filings, in my opinion. And I'm seeing a lot of like an establishing of a pattern. Like this is
Except the
what
Hassan
this
thing.
is
The
just
Hassan
what
thing is
these
pretty
guys
bad.
have been doing for a hot minute. The Hassan thing is just horrible. Yeah.
Hassan is friends with Hitler and Heinrich Himmler.
That was he's a reincarnate. Yeah, that was what the fuck.
That's a little out of pocket. Below is a true and correct screenshot of Doe number 3, providing a link to the TEI video Content Court by Jack the Horty. Content Court Jack the Horty H3 show number 48. YouTube, as can be noted, Doe's number 3 comment has been wiped from the August 28th, 2024 post. Under the H3 Snark wiki page for tools, tips, guides, H3 Snark mods also instructed H3 Snark users on how to create clips of TEI content, so these clips could be posted on H3 Snark. I see where you're going with this. That's gonna be difficult. The created clips bit, depending on the size of the clips. Like if you're like, oh, they posted a 30-second clip of my 1.5 hour video to comment on it, you're gonna have a rough time.
Yeah,
At one point, the H3 Snark mods even instructed users on how to download members-only content. TEI content only accessible to paying members, so they could be posted on H3 Snark to hide their inducement of copyright infringement. The H3 Snark mods completed portion on downloading members-only content from the guide. A true and correct screenshot of the portion regarding members-only content is provided below. TEI issues takedown notices for Also, you notice that we haven't actually talked about what's her name the entire time, Caseytron. We called her a pot smoker at the start.
Yeah, this has actually been mostly. Yeah, we called her a pot smoker, and then we've been talking about the H3 Snark mods.
Yeah.
Oh, and also comparing Hassan to Headless Friend.
Yes.
But there's been very little Caseytron in this Caseytron complaint.
TEI issues takedown notices for infringing posts. Okay, so there are mentioned that they issued DMCA takedown, which is, in my opinion, I think.
There you go. Okay.
Even if you don't have to, I do think it's a good first step, and I do think
you should. You absolutely yes. Yeah. It shows the courts that you made a good faith effort to resolve the situation without involving them.
Yes. Particularly the paywalled content, which is probably even better. Comments that provided YouTube link to entire episodes, or posts that contained a clip of TEI content with a descriptive, non-critical title. The comments were locked by H3 Snark mods, or there were no comments after several hours. August 1st, 2024, DMCA takedown. Issued a DMCA takedown for the H3 Snark post entitled H3 Live Show Behind the Scenes. The post contained a complete version of TEI's video H3 podcast BTS number 53, which was members-only content, accessible only to paying members of the H3 podcast YouTube channel. On August 2nd, 2024, Reddit honored
Dude, this is a lot of infringement. This is way more than just the content nuke.
In this case, right, because I still don't like that for the H3 Snark mods, he's doing a contributory infringement thing, right? A second claim for relief.
This feels like it could be its own complaint, like
this
separate
should
from
be
the
its
other
own
three
case,
creators.
I think. And
I do feel like, yeah.
I feel like this kind of shoots himself in the foot a little bit, trying to push this contributory thing instead of just making it a case.
Yeah, a little bit, but I mean, it's not like, we'll just have to see how it goes, really. The copyright law is so weird, and it really depends, judge to judge, what's gonna happen.
Yeah. This is them issuing more DMCA takedowns, which are totally accepted. I'm just gonna take for granted all these DMCA takedowns are valid, because, if they were...
Oh, it's in a court.
Yeah.
It would be it would be perjury otherwise.
Yeah. H3 Snark's mod's efforts to issue fraudulent counter notifications. That could be interesting. Reddit informed TEI that a so-called counter notification was issued against both these takedowns. The first fraudulent counter notification was issued months later. On its face, the first fraudulent counter notification failed to satisfy the requirements because it failed to include the issuer's address and telephone number, consent to jurisdiction and service of process, and a statement made under penalty of... I would say this is probably
wait a minute.
Their problem.
Hold on.
Yep.
Okay, on its face, the first fraudulent counter notification failed to satisfy the requirements of 17 U.S.C. Section 512 because it failed to include the issuer's address and telephone number, consent to jurisdiction and service to process, and a statement made under penalty on perjury. Okay, I see. Sorry, I thought they were just accused of committing perjury.
No.
Yeah, no, we're good now.
This, I think, is more of a problem with how DMCAs work on these websites.
Yeah.
So I understand that technically this is the requirement, but that's not the requirement Reddit or YouTube really gives you when you issue these counter notifications, because they don't, in my opinion, they don't do it correctly. That's more of a me thing.
That's largely, but I've never had to deal with YouTube's DMCA system yet. But everyone who has dealt with it has said it's pretty much a mess. Even lawyers who have had to deal with it are like, this is a fucking mess. What am I supposed to do with this? So
if I'm defense on this, I'm just saying my client's not a lawyer, so they just did what they were told to do by the website that issued them the requirement.
Yeah.
I think, this is all about the fraudulent counter notifications. Like, I understand where you're going with this. I just, because they aren't lawyers and because these websites handle these so poorly, I don't think it ends up working in your favor in the long run.
Ignorance of the law does not excuse violation of it.
Oh no, I'm not saying like the DMCA is not like or the copyright's not invalid, but the way like DMCA
no, but their counter
work.
Notifications. Yeah, but their counter notifications that they put on themselves, even if they used Utin's site, they did not meet their burden, and therefore, like it's an improper court filing base. Because DMCA, all it does is basically you sending a DMCA notice request. It takes down the video. YouTube basically then acts as an intermediary between both parties to provide their information to then take it to court or otherwise settle in another format. But if they incorrectly and misappropriated their response and counterclaimed like misusing that system, that's still on them. Even if YouTube doesn't make it clear, misuse of the system like that is a violation, both DMCA and DMCA counterclaims, and it's a punishable violation by I think $5,000 fine and up to 6 months in jail. So again, to anybody here, if you're a creator, you really gotta take DMCA seriously, and you should not just react to it willy-nilly. If you get a DMCA request and start all that, honestly, get a lawyer. Get a lawyer to help you through it, because that's the only way you're going to navigate it without it snagging you up.
So I'd have to look more into it, but a quick overview of what I'm finding is the only real way you can be charged for a fraudulent DMCA is if you actively lie on the DMCA, not if you just file it improperly.
Okay,
like I said, based on just like a quick search, so it's probably not as accurate as it should be. Everything just says that realistically the only time you get in trouble is when you provide fake names and fake addresses. And that could be wrong, but
well, that's the practical enforcement. So it's probably more accurate than not.
Which is fair, yeah.
Because there's the actual law, and then there's what can practically be enforced from that law.
Are we still just on, takedown notice? The H3 Snark mods went on a public relations campaign.
I'll take down your notice.
We're about halfway through it, by the way. Still haven't gotten back to Caseytron.
Yeah, we are pages and pages in. We're page 23 here.
This really should have just been about the H3
mentioned
Snark
in like
mods.
3. Yeah, I mean, here's the thing too.
Caseytron should have been like 2 pages.
I do think they have a good case with the Snark mod. Well, I think the issue is Caseytron, Vrogan, and Demnums were reportedly like actively collaborating and working with the H3 Snark mods to conduct this level of infringement. So I understand the necessity of them being involved with these, but again, I think it was mentioned in one of the other 2 complaints. It's mentioned as a point,
as he doesn't
justification of why they're included.
He just says that because they link to
them,
them, they're in collusion. And it's like, this actually kind of works against that. Because this shows that they just hate you, so they'll link to anybody but you.
I mean, yeah. Said it's fair.
Because but
in order, yeah, for the H3 Snark mods to like be properly included with these complaints, there needs to be something that like verifies collusion between these parties.
Yeah.
Otherwise, I mean, again, I feel like this H3 Snark mod stuff is strong, but it would be far stronger if it was its own separate complaint.
Yeah, if it wasn't a contributory infringement on somebody else's document.
It's like, dude, well, they fucking just infringed on it through their actions. Just go after them for copyright infringement, not contributory for any infringement. Like, you're making things more complicated than they need to be in what seems like a pretty open and shut case, if it wasn't for all the fluff you're adding, dude.
Yeah. Public relations campaign to paint TEI's DMCA takedowns as fraudulent to cover up their copyright infringement. To achieve this objective, the H3 Snark mods authored several posts misrepresenting the facts. As Ethan became vocal about pursuing claims against H3 Snark, the H3 Snark mods began deleting their posts, comments, and accounts.
I love that that's what people do. Like, that's gonna help.
Yeah.
Like, people don't understand that something goes through to discovery, or somebody gets a court order, like a judge subpoenas Twitter for all that information. All those DMs that you thought you deleted, guarantee you they're retrievable in some form or another, and like, just the act of deleting stuff because you think you're going to be sued can be veered as a violation.
Yeah,
so like,
I would say, like, at least for smaller people, the idea of having to go through discovery to find somebody actually is a high enough bar that it does work against something.
Yeah.
You know what I mean? Like, it doesn't work with Ethan because Ethan has money. But for somebody that doesn't have money, the idea of going through all of that for who knows how long, kind of like, you know what, it's just not worth
it's a nightmare. It's like, oh, fuck this.
They'll be like, you know what, they deleted their shit anyways, whatever, bye.
Then, you know what, if, like, they were responding to, like, the C&D, like a C&D, and they actually deleted it when Ethan asked them to delete it and stuff, and did the DMCA stuff, that probably would have stopped there. But the issue is, okay, well, now I'm thinking about taking legal action because you have been on complaint this entire time. Now everything is disappearing. Now you're just destroying evidence.
Yeah. So it's something you shouldn't do. However, I also acknowledge that
it's going to be the natural reaction of most people.
Yeah.
Yeah, most people are going to go... I mean, and most people just psychologically are going to, oh shit, I better delete this thing that I could be sued over.
Yeah.
Now, that's not an appropriate response, but it is the normal one. It's the reasonable one, based on, like, average people and their knowledge of the law.
On March 5th, 2025, a YouTuber by the name of The Law posted a video on YouTube entitled, Dear H3 Snark, I See. In the video, The Law admits he was a former H3 Snark user who came to reject the obsessive and destructive behavior he saw taking over the subreddit, documented the acts of copyright infringement by H3 Snark users and H3 Snark mods, including their attempts to conceal their unlawful content, video document. From 118 to 141, the H3 Snark mods deleted post after Ethan announced plans to pursue legal action. From 202 to 455, the H3 Snark mods abused the live chat feature on Reddit to promote harassment and defamatory statements. including promotion of some of the egregious offenders into H3 Snark mods. From 455 to 651, the H3 Snark mods use sock puppet accounts for a false identity for deceptive purposes.
I mean, a good example of like why it's not a good idea to delete stuff like this, like for like a layman. If anybody's seen Better Call Saul, you saw when Saul saw that the old Folktron was shredding evidence in the back room, he freaking went into the bathroom and he wrote a freaking cease and desist in freaking toilet paper in a hurry, because that's how fucking serious of a violation that kind of behavior and activity in response to just being the, oh, I'm gonna sue you, oh, let me shred everything I have. No, you dummy, don't do that.
Yeah. From 652 to 911, how the H3 Snark mods purposely lied about TEI's DMCA takedowns to conceal their copyright infringement and obfuscate their intent to siphon views and ad revenue away. I'm probably skipping this whole next section because this just explains that they created the video and they registered it. So for those who don't know,
yeah,
when you make something, you do have a natural copyright to it. However, you can also register a copyright, which is a lot stronger. If you
register your copyright, it entitles you to statutory damages.
Yes.
You actually get a rubric for okay, if your violation, if your copyrighted work is infringed, this is how much it's worth, this is how much an infringement would be, like $150,000 or whatever. You do not have rights to those kinds of damages with a natural copyright when you create a work. So if you want to actually be able to sue somebody and get all these extra damages and all this extra stuff, you should register your copyright with the Library of Congress.
Yeah. I will say it is, it's very confusing to me on Twitter that a bunch of people seem to think, oh, Ethan actually registered the copyright. It's the first time a YouTuber has gotten the copyright. No, you have a natural copyright when you make it. Like, stuff isn't just not under copyright because you didn't take the time to register it.
Yeah, things are still copyright protected when you create it, and that's a natural application upon the creation of the work. It just does not, that protection particular, it protects you like a bare minimum, almost like a liability insurance, whereas registering the copyright with the Library of Congress will actually entitle you to elevated recompense should an infringement occur. So think of it as the difference between liability and full-time coverage.
Yeah. Another good example, that's not really exact, but probably a good way to explain it to people is it's kind of like saying you don't own something just because you don't have insurance for it. Like, no, you still own it. The insurance just makes you more protected.
Yeah.
But it's still yours.
That's a good comparison. It's still your thing.
Yeah. Yeah, the nuke was shot and edited. Copy. The deposit copy varied slightly from the broadcast version. The broadcast copy did not contain the conclusion and sponsor segment. What, you didn't want to copyright your sponsor segment?
No, I don't think he could.
Why not the conclusion?
But yeah.
What was wrong with that?
Not sure.
Like, it's not a big deal. I'm just kind of curious. Thought your conclusion would have kind of been, you know. And third, Viner visual edits were made. Okay. I'm just curious why the difference is. I get the sponsor segment because it's a sponsor, but removing the conclusion and doing visual edits, I'm just kind of like, why? I'm curious. The Nuke is a tragi-comic documentary critiquing Hassan and Twitch. If that's how you want to...
Is that what it is, huh?
We want to call it, okay.
A tragi-comic? Oh my god, what is that? Stop it.
So this is just
explaining
the
Nuke.
I'm
sorry. I love that they're italicizing the Nuke. Well, which is appropriate. It's good formatting. It's just funny to me. The Nuke.
How many pages do you go over your Nuke? Sorry, I need to count, like, as we're going.
I mean, this is appropriate because this is the content that was infringed upon, so
It is.
he should go over it in detail.
We're not counting this page because it's only like the bottom of the page. You have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay, about 10 pages. A fifth of your legal filing. God, that's just a lot. And see, we're back to Caseytron, but it's still H3 Snark promotes Caseytron. This should have been an H3 Snark lawsuit, in my opinion. Throughout January 2022, Ethan built up public interest in the nuke by frequently discussing it. H3 Snark anticipated the nuke with religious fervor to defend their proverbial Grand Mufti. Stop calling Hassan the Grand Mufti! It's not a Hassan lawsuit.
It's weird.
These fanatics, however, did not want to watch the authorized version of the nuke because TEI would reap the benefits from the views and resulting advertising revenue. The H3 Snark mods knew there was a huge demand to watch the nuke through unauthorized channels and promoted group viewing session. On January 30th, 2025, the day before the nuke was released. Was it really released like the first day of February? Jesus Christ. So long ago, and it doesn't feel like it was.
I know, 4 months ago. That's kind of insane.
Yeah. I'm just so fast. January
Time is
30th.
being a speedy boy.
Go number 3, Duet Torn Sarah, as an H3 Snark mod, and on behalf of the H3 Snark mods, created a pinned post entitled Megathread Content Nuke Where to Watch and Discussion. First inducement post. This pinned community post, the first inducement post featured at the very top of the H3 Snark page, the community highlights section before any other posts were visible. The H3 Snark mods did this to maximize the visibility of the first inducement post. The first inducement post featured Caseytron as a place to watch the news. January 25th. Oh, it was released. I was released in January. I forgot January has 31 days, not 30. My bad. January 31st, 2025, Nuke was released. The Snark mods created and updated a pinned community post titled Ethan Klein's Content Nuke on Hassan Piker, H3 Snark Megathread. Second inducement post was also a pinned community post that was featured at the very top of the H3 Snark page to maximize visibility. So I'm going to say this, right, about the first inducement post here. I am curious as to how that would play out in court, because it was not released at the time. So I definitely understand the idea of it, like, shows the copyright infringement. I think it's going to be a weird argument to argue preemptive copyright infringement. I'm just curious how that plays out, like...
Yeah, I'm not quite... Yeah, that's gonna be an interest. I'm not sure how that one's gonna play out.
I definitely think it probably should be in here to show, like, the pattern.
Yeah.
But trying to actually say it was copyright infringement in itself, I don't think it'll pass.
Yeah. We'll have to see.
I do want to see, like, two very good lawyers debate that out.
Honestly, what I want to do, though, and what we're going to be doing is I'm going to get the court listener up for these 3 cases, and I want to see Frogan Denham's and Caseytron's response to complaint.
Yeah.
That's gonna be the good one. Cool, we're getting their responses on video and on stream and stuff. I want to see what their lawyers put to paper in terms of a point-for-point response on these complaints.
Yeah. I'd be really interested in how that plays out. So this is a decent enough section, the law of fair use and reaction videos, and explains fair use itself. The statute sets forth 4 non-exclusive factors courts consider to evaluate fair use. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit and educational purposes. The nature of the copyrighted work, the amount and sustainability of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. This is something that came up in the Sargon one. Is number 4 really damaged the person that was suing him? Because they basically said, well, the market of people watching the infringing content is not at all the same as the market of people that would watch your content to start with. So I think the fact that this is on the H3 Snark mods, it really hurts the 4th precedent. You're probably the strongest as your number 1, which is the purpose and character of the use specifically, because they have all kind of admitted that it was malicious. At least to some degree they've admitted it. Sorry, allegedly. They've allegedly admitted it was malicious. Don't need to get sued by somebody else. I'll be honest, as somebody who's read through fair use a couple times, I still don't fully understand the nature of the copyrighted work. Other than like maybe it means if it was non-profit or educational kind of stuff. The second prong is always kind of confusing, but that's a me problem. Could add a case of conspiracy to commit copyright infringement, just spitballing. Good luck with that, I guess.
Probably not. I don't see a conspiracy case being tried here.
Yeah. This is the thing with fair use, right? And we've talked about it before, but fair use is very loose. Honestly, other than them admitting to the malice in the first prong, I would argue that you almost can't come up with an argument for them fitting the other prongs.
Well, that'll be up for the court to decide.
Yeah.
I mean, he's getting ahead of the argument because their main defense is going to be fair use. So he's just kind of going, well, this is what they're going to say. This is why I say this does not meet the standard of fair use. So this is him just getting ahead of the argument that is going to be in their initial response to the complaint. But that's pretty much all this is.
Yeah. He cites the Andy Warhol case, which honestly, I've heard of it. I haven't read it, so I can't like comment directly on it. But it basically says just because the new version has a further purpose doesn't necessarily make it fair use. A matter of degree and the degree of difference must be weighed against other considerations like commercialism. While a use that has a further purpose or different character is said to be transformative, transformativeness is a matter of degree. Indeed, an overbroad concept of transformative use, one that includes any further purpose or any different character, would narrow the copyright owner's exclusive right to create derivative works. To preserve that right, the degree of transformation required to make transformative use of an original must go beyond that required to qualify as derivative. I would like to say to people, just kind of in general on number 46 here, transformative has historically been defined very, very broadly. Like, in my opinion, excessively broadly.
Overly broadly would be, and that's the concern with these cases, is it's going to narrow the definition of transformative to a point where it's going to permanently change the landscape of content creation as we know it. That's the concern here.
Yeah, it's something that everybody worries about with these cases, is it's historically been overbroad. So if we go with the historical definition, there is good chance that you're just not going to make it at all. But if you manage to change the historical definition, well, you've now narrowed the landscape for literally everybody. And now everybody has to go back and relook at everything they've done in the past and be like, is all this causing a problem now? Or like, will it be causing a problem in the future? Because then I had to reconsider how they do content moving forward. The first factor also relates to the justification for the use, both in the broad sense and in the narrower sense. A use is justified in the broad sense if it has a distinct purpose that furthers the goal of copyright namely to promote the progress of science and the arts without diminishing the incentive to create. I would actually possibly argue that at least to some degree, like Denham's and Frogan and them actually meet this criteria because it's of a political nature. And it is to a degree furthering a political
there,
discussion.
But not quite. I can almost get there, but I just can't. I can't cross the line on that one because it's just not. It doesn't line up with the requirement in my eyes. It gets close, but it's just not quite there. But it's definitely close enough. I would bring it up as an argument.
Yeah, I think it's close enough to the line that it could swing either way. It's definitely one of those where, like, if I had to put a number on it, it's like 60-40. It's definitely not like a 100%.
Yeah, that's probably appropriate. Yeah, no, it's not like a Hail Mary or anything, but it's a good jab.
Yeah. A use is justified in the narrower sense when it is reasonably necessary to achieve the user's new purpose. Such justification is particularly relevant to assessing fair use where wide dissemination of a secondary work would otherwise run the risk of substitution for the original licensed derivative. I would argue this is, again, like a 60-40 thing because of the political nature of it. And I would say both kind of for the same reason. Because they
that's
do...
the thing. It's the content is political, like the content they're covering, but it's a critique of these individuals and how they cover the content. So the content in question is not in of itself political. It's in the political sphere, but it's not strictly a political thing. It's a critique video.
Yeah. Honest opinion, if it gets rid of chair streamers, it'd be good, but the risk of making it overly restrictive is too much for me. That's the thing. I feel like we should be able to deal with chair streamers without having to narrow it at all. I kind of feel like they're just by
chair
default
streamers
already
being like out of the what we already have in place for like a rubric, like that's already like a chair stream. Absolutely, it's not transformative enough, and I think it's been found a couple times.
Yeah.
Did I disappear?
You did for a second, and you came back.
Okay.
I think the biggest question here is the amount of portion used. It's going to be the biggest question to ask for this. I actually, in most of these cases, don't think it will be, because it's the amount of portion used in relation to the new work. And with, like, I think it was Denham specifically, it even says it in his filing, that she covered the 1.5 hour video over the span of 5 hours. And it depends, like, what content is in there, obviously, to a degree, but you have to kind of match both together, right? You can't just say, oh, they used my entire work. Because what if the entire work is 30 seconds? Like, if it's a short little, like, meme clip. Well, then I use the entire work.
Then it would be proportional, and so if you use the entire work and you did not transform it appropriately, then yeah, that might be a problem.
Yeah, but that's what I'm saying. It's both
even
parts.
If it's only 30 seconds long. Now, if you only use 5 seconds of that 30, well, you're using 1/6 of the video. That can obviously be defended as fair use far more appropriately than use of the entire video. But again, it's not how long the video is, it's the percentage of the video used.
Remember an example here, I guess. A critical book review illustrates how a secondary use must be justified both in the broad and narrow sense. In the broad sense, the use of the original serves as a different purpose than the book, criticism and commentary. In the narrow sense, each quoted passage within the review likely serves a different purpose, an object of criticism, than it does in the book. Critically, this may not always be so, and a court must consider each use within the whole to determine whether the copying is fair. Consequently, even book reviews are not entitled to presumptions of fairness. There are several indicia. I'm sorry, I can't pronounce words, chat.
Indica?
Indicia, I don't know.
Wait a minute. Yeah, but indica is a type of cannabis. I know we're talking.
What?
Wait, shit, that's right. How far? Yes, indica and sativa. That's the two main types of cannabis there are.
I don't know anything about weed.
We are now 40 pages into this 52-page document. Where the fuck is Caseytron?
Yeah. We're still talking about the H3 snark mods. We're almost at the end.
Like, for real, though.
I think that's actually what makes this document as weak as it is, because at the end of the day, it is a lawsuit against Caseytron. And if I kind of get up there as the lawyer, I have to defend, like, the one thing, which is admittedly a damning thing, right? But then I'm like, Your Honor, he just has nothing in this document alleging my client did this. He just said that she smoked weed while covering his video.
It does feel more like... it feels more like he's going after these snark mods than Caseytron in this complaint. And that does feel weird to me.
Yeah, because I've kind of seen this work out in courts before, where he just ends up hitting nobody then. Because the lawyer says, well, he's not really going after my client, he's going after these people, and I don't represent these people.
The problem is Caseytron's infringement was so blatant and so visible, it doesn't need to be covered with very much. I mean, the first couple pages was probably enough. The question becomes then, though, why did you include the snark mod stuff in this complaint when that's the bulk of the complaint? You could have easily had Caseytron, Rogan, and Denims all on their own, like, 10-page complaint, Yik Huck, Lion Seeker, Slam Dunk, whatever you want to call it, and then have this much larger complaint, like, appropriated to the H3 snark mods in their own freaking lawsuit. Like, that's how I would have done it. Maybe there is some reason why they're not doing it that way. I just don't understand the strategy.
Yeah, I'm not... I just don't think it's going to work out well for him. When use for a criticism or commentary is not sufficient transformative to justify a secondary use. The commentary has no critical bearing on the substance or style of the original composition. The claim to fairness in borrowing from another's work diminishes accordingly. And other factors, like the extent of its commerciality, loom larger. Indeed, a loose topical connection to the original work is equally problematic. I'm not sure about that. A loose topical connection with the original work is equally problematic. Where the fuck did you get a binky from? I just look over at the other. When a defendant copies more than is necessary to facilitate comment or criticism, the law is clear that to be considered transformative criticism, the aspects of a work that reproduce another's aesthetic expression must be in service of a commentary on that. It is not enough for part of a work to have a transformative purpose. And when the use of the copyrighted work is not consistently transformative, for example, when clips are played without much interruption, if any, or used in excess of the benign purpose. And the use of voiceovers, headlines, or captions, or wholesale copying, sprinkled with written commentary, fails to sufficiently transform a copyrighted work under the first fair use factor. Additionally, when copyrighted work is used to simply illustrate what that work already depicts, the infringer adds no further purpose or character, and copyright law treats the infringer as free riding on the inherent value of the original. So I will say because it says Elvis Presley up here, it sounds like they might be citing music cases, and this is going to sound weird because you would think that they apply equally. Historically, music is treated much differently in copyright than anything else. It's not really fair, in my opinion, but
music is also where, like, the most of the copyright cases exist. So, like, if you're going to... If you're submitting a copyright infringement case, you're gonna, like me just said, it's not treated the same, but it's almost inevitable that you're going to end up citing a music case once or twice in your infringement lawsuit.
And I don't know why, because you would think bringing up some of these cases, like, yeah, that's a fair argument, but looking through court cases about copyright that have nothing to do with music, they are always treated differently. It's just music just gets like a special pass that other works just don't.
Yeah, I mean, look, Metallica literally basically is responsible for the Digital Millennium Copyright Act.
Yeah.
Like, literally, a band, a heavy metal or rock band, whatever you want to call them, is responsible for one of the driving forces for, like, content creators today, like, in that this happened 25 years ago.
Yeah.
That's insane.
It's just one of those
we
weird
need to
things.
Reevaluate
like,
DMCA.
I see why they're citing it. However, typically it just doesn't play out the same in a courtroom. I still hate that the music industry is just given so much leeway that nobody else is.
Yeah, well, it's a good one now. Sorry, I just saw Warhol.
Oh yeah, no, they bring up the Warhol multiple times.
Yeah, it's a good one. Elvis Presley might work in their favor on this one. That's a good one to quote as well for blatant infringement.
Yeah. They also keep mentioning Mong, which I admittedly don't know anything about this one.
I'm not familiar with that one. I would have to look that one up.
Yeah, I've never heard of that one. The name itself doesn't even ring a bell.
I've heard of it. I just can't, literally, I'm drawing a blank. Like, in my mind palace, I went to my Mong folder. There's nothing in there.
Yeah.
Oh, shit.
First fair use factor does not favor any user who wants to reach different buyers in different markets consuming different products. Warhol. The first fair use factor might not favor them. However, I've seen multiple court cases where they've actually cited that as almost the sole reason for why it didn't count as infringement. So I think that might just be like an old thing in the law that people just haven't kind of come to terms with yet. Which also it could just be judges interpret it differently. Which judges often do.
Boomer judges. Okay, Boomer. Whatever you say, Boomer.
Yeah. As mentioned, the degree to which a secondary use has a different purpose or character must be weighed against other considerations like commercialism. The undisputed commercial character of the defendant's use, though not dispositive, tends to weigh against a finding of fair use. Commercialism examines the degree to which the new use exploits the copyright for commercial gain as opposed to incidental use as part of a commercial enterprise. So this is something they're bringing up a lot. They're really hammering home the commercial fact of it. And I will say in recent years with other court cases, the court has really pulled back on the commercialism angle. At least most courts have. Because what is considered commercial these days is so much broader than what it was back then. Right.
Yeah, but like commercialization is like one of the central aspects of whether or not something is actionable, because commercialization allows damages to be easily calculated. So I don't see them moving away from that.
I have seen in a lot of copyright cases, specifically kind of around the YouTube stuff, is they have somewhat pulled back a bit from the commercialism angle, specifically just because technically these days everything you post online is immediately commercial. Like even now on Twitter, your Twitter page can be commercialized. And it's not necessarily that they don't believe the commercialism matters. It's I think they want a higher bar for what is considered commercial than just you posted it online and stuff online is naturally commercial. And that could just be like a boomer thing with judges of them not because I've seen it sometimes with judges too. They don't understand how the money is made through YouTube necessarily without like a direct purchase tied to it. But I think some of it is just they want a higher bar. Devistar for 1669.
Maybe commercialism is monetization might be a more appropriate term here.
Yeah. Devistar for 1669. Aren't you two a sight for sore eyes? Aren't we just adorable, chat? I don't know if you saw it earlier, Ava, but somebody did come in here and say, like, try to call us children.
Oh, did that happen?
That was forever ago, but somebody came in and tried to call us children and said we didn't know what we were talking about.
Well, that's fair.
It's like, okay, yeah, sure. Courts consider whether the defendant was motivated by profits and profited from the publication. That is one of the things I do think is courts want to see a bit more. the motivated by profits and profited from the publication kind of thing. Specifically the first bit. Further, if the defendant is not advertising a scholarly critique or historical analysis, but instead seeks to profit at least in part from the inherent entertainment value of the original work, the use is commercial. Yeah, that makes more sense. It's basically saying, like, you're specifically trying to make money because you know the original work you're using is popular and people will want to watch it.
Yeah.
Still citing the Elvis Presley case. Finally, commercialism exists when a secondary user makes unauthorized use of copyrighted material to capture significant revenues as a direct consequence of copying the original. It's a new case. Blanc versus... I don't want to say that out loud. I feel like YouTube gets you in trouble when you say that word.
I mean, that's fair.
Blanche versus a K word. It sounds like a C word that I'm not allowed to say.
Blanche versus rhymes with moons.
Yeah. That case I also haven't heard of before. I'd have to look it up. It's in 2006 though, so it's actually not that old. At least I'm assuming that's a Second Circuit Court 2006.
Yeah. That is what that is.
In Hosendai, the court found the first fair use factor favored fair use because the Klein video was quintessential criticism and comment on Haas's video. Namely, consistent... I understand why he's bringing up his own case, but some of it feels like he's just, like, really stroking himself off. Consistent mockery of Matt Haas' performance, dialogue, and plot lines. The Klein video was consistently transformative by interspersing relatively short segments of the Haas video with long segments of Klein's commentary. The second fair use factor, the nature of the copyrighted work, typically has not been terribly significant in the overall fair use balance. And then he cites McCucken. I've seen that one cited a couple times. Again, that's one I'm not...
McCucken.
McCucken.
I love that fucking... No, I heard McCucken now.
Oh, sorry. No,
that's way better.
It's Gucken. We can call him McCucken, though, if you want.
Yeah, McCucken. It's too good.
Blue Sky for 5. Honestly, these children definitely know more about the law than that guy. Thank you. Ava is the lawyer here. I am the pro se Shota. I represent myself. This factor examines...
I am the inactive first year associate of a family law firm. Okay, that's about as much knowledge as I have, okay? Not a lot.
Fair.
But enough, I guess.
This factor examines the extent to which the original work is creative and whether it is unpublished. Even when a work documents a real event, the work can still be creative because it is the product of many technical and artistic decisions. Whether a work is published is defined by whether the author exhausted the right to control the first public appearance of the work. The mere fact a work is published does not weigh in favor of fair use. In Hosendaya, the court found the second fair use factor weighed against finding fair use because the Haas video was a creative work despite the work being published. The third fair use factor examines the quantitative amount and qualitative value of the original work in relation to the justification for that use. Consequently, the third fair use factor circles back to the first factor because the extent of permissible copying varies with the purpose and character of use.
Accurate.
Somebody gave me a head pat too. Head pat. When the amount of work used is substantial with respect to the infringing work, it is evidence of the value of the copyrighted work. Indeed, copying an entire work against... militates? Sorry, Chad, I'm not good with words. Against finding a fair use. Any VHT Inc. versus Zillow Group. Wasn't Zillow the people that did the houses?
I think so.
I've never heard of that case either.
I want to look that up.
That was a Ninth Circuit court in 2019, so that's very recent.
Reimagining real estate. They're a real estate company.
Yeah. I wonder if it does have anything to do with them, or if Zillow Group is somebody else.
Yeah, no, this is it. This is them. I found their Wikipedia article.
Yeah.
They found it in 2006.
Fair.
February 8th.
I'm kind of wondering...
19 years ago.
It's got to be like for an advertisement or something that they... Because it's a fucking real...
Yeah, it must have been some kind of infringement.
Realty group.
Hold on, what is the name of it?
VHT.
Okay, hold on. Oh, there it is. It's one of the first. There it is. Okay, here we go. Yeah, plaintiff Z. You guessed right. Plaintiff VHT. Real estate photography studio.
Yeah.
So obviously Zillow infringed upon the copyright. Used probably some photos and stuff that were created by VHT that were copyrighted and registered, and yeah, they sued over it and they won.
It looks like they won half of it.
Yeah, it looks like that. Yeah, you're right. I was just reading that part.
Yeah. Ninth Circuit finds online real estate marketplace Zillow did not directly infringe photos from VHT Real Estate Photography Studio by hosting those photos and making them available to others. But Zillow's tagging and cataloging of other photos to provide search capabilities did constitute direct infringement and was not transformative fair use.
Interesting.
I will say when it comes to copyright infringement, it becomes so much more confusing for me when we're talking about photography. Because like some of the cases I've seen for that are
photography
just...
gets a lot more, it has too much to do with like the judge's subjective view of what fair use is, how much is transformative and stuff like that. Like there's no rubric.
Yeah, photography
because
becomes
art in photography and stuff like that is by its nature subjective. So how do you add a rubric to something that's inherently subjective?
Yeah, it gets very difficult to actually follow along with it. Covered that one. If, however, the new user only copies as much as necessary for his or her intended use, this factor will not weigh against the new. In Hosendaya, the court found that the third fair use factor was neutral because while Klein's video copied a great deal of the Haas video, the extent and quality of importance of the video clips used by Klein's were plainly necessary to commentary and critique. The fourth fair use factor is undoubtedly the single most important element of fair use, Harper and Row Publishers Incorporated versus the Nation Enterprises. Big companies, or big publishers, or whatever the fuck is going on there. While the first
that's a big one.
Yeah, while the first fair use factor considers whether and to what extent an original work...
I think that's a 1985 case.
Yeah.
Here we are.
Secondary use have sustainable purposes. The fourth factor focuses on actual or potential market substitution.
Yeah, and that's why I keep mentioning substitution so much, is because it's a big thing to look at. If they're offering the copyrighted work and viewing it through them as a substitute to the original, that is actionable. And that very clearly happened here.
Yeah. The fourth fair use factor encompasses both the extent of market harm caused by the particular actions of the alleged infringer and whether unrestricted and widespread conduct of the sort engaged by the defendant would result in substantially adverse impact on the potential market for the original and the market of derivative works. Even when there is little direct evidence of actual market harm caused by the secondary use to negate fair use, the plaintiff need only show that if the challenged use should become widespread, it would adversely affect the potential market for the copyrighted work. I would actually argue to a degree this somewhat hurts your case. In the fact that the longer a video gets, the less likely people want to watch it. So if her video became just as widespread as yours, I think a majority of people would rather just watch yours. Just from like a time perspective.
Yeah, that's true.
That's kind of where these cases become very complex and why I wouldn't want to be on either side in one of them. Because there's so many arguments.
I definitely would not want to be a copyright lawyer. Like, this is a headache just trying to thought through, like, as we read the complaint. So, like, imagine how annoying it is for the actual attorneys on this case, on either side.
Yeah. The fourth fair use factor must also take into account the public benefits the copying will likely produce. Google versus Oracle America. I'm assuming they meant Oracle.
That's
like
a big one.
I actually haven't seen that one. Apparently it was recent, though. It was 4 years ago.
Yeah, that's a recent one. Yeah, yep. It was a COVID era.
In other words, does the use serve copyright's goal of enriching public knowledge? Quoting the Authors Guild versus Google Incorporated, which was the Second Circuit in 2015. When the original work is associated with dangerous misinformation, does not serve the public benefit, and results in actual and reputational harm to the market for the original work. Even when the primary markets do not meaningfully overlap, the National Academy of Television Arts and Science versus Multimedia System Design. That was also 2021, it looks like. In Hosendai, the court found the fourth fair use factor weighs in favor of a determination of fair use. The Klein video did not usurp demand for the copyrighted work, therefore resulting in a loss for the infringee or unjust enrichment for the infringer. To the contrary, the Klein video did not serve as a market substitute for the Haas video because the Klein video transformed the Haas video from a skit into fodder for caustic moment-by-moment commentary and mockery. Consequently, the Klein video does not offer substitute for the original.
Chad, I cast vicious mockery.
Yeah. Now we're finally back on Caseytron. Caseytron's group viewing session failed to make a fair use of the nuke.
Holy shit, what page are we on?
44 out of 52.
44 out of 52. Amazing.
It is readily apparent that the primary purpose of Caseytron's use of the nuke was to offer a group viewing session of the nuke as a substitute for the original. This is evidenced by A. Caseytron begins her group viewing session 13 minutes after the nuke was released to the public. The timing of Caseytron's group viewing session of the nuke demonstrates that she did not pre-screen it to formulate her opinions prior to the broadcast. Rather, Caseytron timed her group viewing sessions to occur shortly after the nuke was released to capitalize on the public interest in the nuke and siphon as many viewers away as possible from the original to herself. So I will say that this could go, I could see this going either way, depending on like the legal party's arguments. In other words, her priority was to personally benefit from providing a substitute for the original, and any commentary and criticism was a mere afterthought. Immediately prior to watching the nuke, Caseytron states, "I know a lot of people have been waiting to watch this without necessarily supporting anything Klein, so we're going to watch it. This is, again, your strongest argument. Really should hammer this home. Instead, you've got, like, you mentioned it twice in passing. You really got to hammer this home, in my opinion."
Yeah, big time.
Caseytron's group viewing session suffers from a poverty of any commentary in general, let alone on the style or substance of the nuke itself. For example, over the course of 10 minutes, Caseytron makes 5 short comments, some completely unrelated to the nuke. I don't know anything about this stuff. Here we go. So now he cares about genocide? Question mark. Okay, look.
Oh, Jesus.
Okay, so I'm sorry, I didn't notice this was a secondary quote. So one of your quotes to prove that she was not, like, paying attention was, "Here we go," right? That I don't know why you included that. Like, that has to have other context, because by itself, I'd be like, okay, that doesn't mean anything. Number 3, also don't think this helps your case, because you were posting fucking videos of Hitler, dude. Like, yeah.
Yeah. He was.
Number 4,
I mean, it's true.
America's
America's bad. What the fuck?
I heavily disagree with her, but this is her, like, disagreeing with, like, your takes. You can't say these are unrelated to the video.
Okay.
I saw your video. What's
wrong with them saying that it's true? What is happening here? These are so weird.
Like, this first one is your best one. I don't know anything about this stuff. Which, admittedly,
okay, so... Oh, hold on. The nuke itself, for example, over the course of 10 minutes, Caseytron makes 5 short comments completely unrelated to the nuke. Okay, so basically this is saying that and this is taking like it like in a little bit, like a little portion, but it's showing that out of 10 minutes of content, she made 5 very short statements, proving that this is not meeting any kind of standard or rubric for fair use or fair like commentary.
Yeah.
I think that's what's being made here. That's the point, but it does kind of read weird in a vacuum.
Yeah. Caseytron admits she has no idea about like world politics, geopolitical politics, or anything
oh my
like
god,
that.
bro.
Or capable of commenting on the vast majority of the points raised in the Nuke. Example 2313 to 2413. In other words, Caseytron admits she is not competent
this is a
to
little bit
provide
of a
meaningful
sidebar,
commentary.
but I'm like this happens with Rogan, Caseytron, Caliente, even like they go, okay, so I, as this person, don't feel that I can talk on this, and then they proceed to talk on that for the next 2 hours.
Yeah.
Like it doesn't help me. Like, oh guys, I'm not qualified to talk on this, but
I will say, personally, I find this would be weak in court, or in my opinion, it would be, because he's now trying to argue that his video is about politics and geopolitics, which is why she clearly isn't competent to provide meaningful commentary on it. Your video is a drama video trying to call out Hassan and his friends.
Yeah, exactly. Like there's Caseytron says, Caseytron admits that she has no idea, like, world politics. Okay, so if you had said Caseytron states irrelevantly, because again, this should not be considered a political video, but you here are kind of making it one or implying that someone believes it is.
Yeah.
I.e. Caseytron. So this doesn't help in proving your copyright infringement having happened at all. Like, I wouldn't even include it.
Relatedly, Caseytron repeatedly states she needs to watch the Nuke again with Mike's analysis. The Mike Caseytron is referring to is Michael W. Bauer. Bauer is a failed Nepo baby who is a prolific purveyor of misinformation to the public for over a decade.
I'm so sorry, but this is so, like, oh, by the way, this guy, fuck him, like, out of nowhere, like, freaking 45 pages in, you just, like, fuck this guy.
If Ethan was a more likable person, this would come across as a Trumpism. But he's not a likable person, so it's just kind of like, wow, Ethan, this is a bit cringe.
A little bit.
Because this is something I could see, like, a Trump saying, and this guy,
there's a son of
Michael
a former
Bauer,
Pennsylvania state rep. Why are you doxing the shit out of this guy?
Yeah.
Wait, that's all you're doing here to me. Like, what the fuck?
Yeah.
He lived at this address. He went to this school. Like, what are you doing?
Now he's talking about their parents. Son of a representative, lost her seat in 2010. Bauer changed his political affiliation from Republican to Democrat to run against State Representative Justin Simmons, the man who defeated his mother in the Republican primary of 2010.
Dude, we are so lost in the weeds right now.
What is happening? Why did we start going on about this?
We are so in the fucking weeds right now. Yeah, I don't know what's happening.
We finally got onto Caseytron, and now we're giving like a political history of this Bauer guy. Great privilege of going to and completing law school in the University of Pittsburgh. Despite having an opportunity many would envy, Bauer squandered his education after law. What are we? Then what happened? You were so close. We were finally on Casey.
Doesn't like this part. You know what would actually be really funny? This actually isn't even Ethan's submission. This lawyer just particularly hates this guy and just decided to add this in. Yeah, he just Ethan has no idea about this semantic shade that was thrown at this irrelevant party.
Had not relied on or applied his legal training to impart legal advice. He did not actively prepare for the bar examination and had not yet scheduled himself to take the bar, nor did he claim to be working with the law for a lawyer or a judge as a non-lawyer assistant.
Fucking what?
In 2014, Beyer ran against Representative Simmons for his mother's prior seat. In his petition, Beyer stated his occupation was a lawyer. The Pennsylvania Supreme Court took the drastic remedy of invalidating Beyer's petition because his description of occupation was both materially defective and issued with knowledge it could mislead electors as to his credential for the office of lawmaker. While Beyer eventually ran as a write-in candidate, he lost the election by 22.2%. Admittedly, depending on how many people are running, that's either not much or that's a massive amount.
Yeah.
Afterwards, Beyer blamed his local Democratic Party for the misrepresentation in his petition, claiming they were responsible for completing it. Beyer's alibi raises more questions. Why are we litigating this? What is going on? We got 1 page of Caseytron, and now we're on 3 pages of this random ass guy. Beyer's alibi raises more questions than answers.
After failing at a political career, what the fuck is happening?
Yeah, after failing at a political career, it was handed to him on a silver platter.
Caseytron. There we go, we're back on it somehow.
Finally.
For a paragraph.
Caseytron is often too obliterated to come. This is such a weird segue, by the way.
To use the term obliterated in this manner in a court filing, I'm sorry, is fucking hilarious. That vernacular, that's a connotative definition of obliterated, right? So that reads to me ranks you fucking just spontaneously got Thanos or something. She's too obliterated. Oh shit. I know you're too under the influence is what he means. But again, this is a court document, so just to have it defined in that way and in that context is kind of silly to me.
Indeed, Caseytron is often too obliterated to comment on the nuke and instead stares blankly at her computer screen. The span of 2 hours and 7 minutes. Caseytron smokes marijuana frequently in a highly concentrated form through a vaporizer for nearly 19 minutes, which is 3 minutes more than Caseytron speaks during her group viewing session.
Oh, Jesus.
At one point, Caseytron is so wasted that she states, "What is happening? I'm trying to follow, but I lost the plot." More notable than her dearth of commentary and copious consumption of cannabis is the sound of what appears to be Caseytron repeatedly emitting flatulence on stream. And he provides 1, 2, 3, 4, 5 different sources for her farting during the stream.
But why? Why? Oh my god, there's no point for this part. This is just useless shade.
Yeah, again, this is one of those things
cool. You got haha, she farted.
We already
Why
covered
are you counting the number of times she farted in the fucking reaction? That's weird.
Yeah, we already covered the jury thing earlier, that it seems like he just has to put that, so in case maybe he does want it in the future, he doesn't waive his right to it. However, if he truly did want a jury trial, if I'm the lawyer, I'm pointing this out to the jury and being like, he's just brought us in here to humiliate my client for no reason. Why else would he include this useless bullshit in his filing?
She farted. Write that down, timestamp it.
The nuke takes the vast majority of the screen for Caseytron's reaction. Caseytron's objective was to provide a large and unobstructed view of the nuke to her audience. In contrast, Caseytron sequesters herself for a small portion of the screen that de-emphasizes her presence, particularly relative to the nuke. I will say that is one thing that I think it was either Denims or Frogan did better, because the actual content nuke video took up 1/25 of their screen because they wanted to show their face and tits all over it. But they had the content nuke in a tiny itty bitty little window at the bottom of the screen. Caseytron's use of the nuke was highly commercial throughout her group viewing session of the nuke. Caseytron solicits donations and her donation goal at the top of the screen. On her Twitch page, where Caseytron's group viewing session was located, Caseytron solicited paid subscriptions, donations, and bits, a different form of monetary compensation on Twitch. Each time Caseytron receives a donation or paid subscription, an announcement would play over the nuke. Indeed, during her group viewing session, the nuke, Caseytron received numerous paid subscriptions and donations. Further, Caseytron received advertising revenue from her group viewing session of the nuke. This is one of those I completely see where he's coming from, where the lawyer's coming from, of the over-commercialization of it. However, if it was me, I would have left out the part where each time she receives a donation, it plays over the nuke. Because then it's like, okay, so you're saying that the money she's making is a problem because it's actually not playing your content. And that's how it would come off to me. I would have just left that part out.
I think it could have been phrased a little bit differently. No, I would have definitely included it because it's, but I would have phrased it very specifically to show that, well, like, she's actively receiving money, donations, contributions for viewing this. I wouldn't make it like a big...
I'm not removing the whole thing.
It phrases it here. No, but it phrases it here like, oh, there's a problem of it playing over the nuke. Like,
yeah.
Well, that should be a good thing.
For me, I just want, if it was me, literally just this line. I don't like that one. I think it doesn't help your case.
I don't think you need that.
Everything else, perfectly fine. This line, I would have just deleted it because it's going to sound weird, and I think the other lawyer is going to jump on it, if there is another lawyer, and be like, they're complaining that we're not showing more of their content. It might be a stretch, but I can see somebody doing it. As to the second fair use factor, the fact the nuke was released 13 minutes prior to Caseytron's group viewing session does not weigh in her favor. Further, while containing numerous documentary and factual elements, the nuke contains numerous creative elements which weigh against fair use. I will say, I've never particularly understood the secondary factor, so I'm just going to take their word on this one. The second factor has always given me a headache.
Yeah, we don't have to go over that one.
As to the third fair use factor, this factor weighs heavily against fair use. It is readily apparent that Caseytron's use was excessive for any potential criticism of the nuke, particularly in light of the minimal level of commentary and highly commercial nature of Caseytron's group viewing session. This is particularly true when Caseytron repeatedly provides brief statements, many of which have little to no critical bearing on the nuke, after showing long, unadulterated segments of it. That's a good one. You're good there, in my opinion.
Yeah, that's a solid argument.
The fourth and most important fair use factor weighs on the most heavily against fair use. It is readily apparent that Caseytron intended and succeeded to provide a market substitute for the nuke for the reasons set forth below. Her statement before the group viewing session, which again, yeah, you need to hammer this one home. This is the best one you got. There's some other good ones, but this is the best, definitely. Showing the nuke in its entirety with minimal commentary, also good. Starting her group viewing session 13 minutes after the nuke was released to the public, when the interest in the nuke was at its apex. This one I could honestly see going either way, depending on the judge's knowledge of the internet and the arguments the lawyers make. The first, why? Not the H3 snark mods. You haven't proven that they have a collusion thing going on there. That one's not helping your case. Due to Caseytron siphoning the audience for the nuke to her group viewing session, TEI lost views and advertising revenue it would ordinarily receive from the individuals who watched Caseytron's group viewing session instead of the nuke. For that one, I feel like if I'm the lawyer, what I'm showing is your average viewer count and showing that your average viewer count was way above what it normally is, because these kind of dramas do get that big. And then I think it becomes a back and forth argument on what constitutes diverting attention away. And then Caseytron's conduct did become widespread. Several other members of Hassan's waiting room conducted a group viewing session of the nuke immediately after its release, which resulted in further loss of viewers and lost advertising revenue to TEI. I don't think this helps. I think they're trying to say that her behavior became widespread, so other people started doing it, so it's her fault. That one's a stretch. I don't even know where to go with that one. And then everything else is the claims for relief chat. It's pretty straightforward. They want, wait, did they change it a little bit for this? I think they sort of did. TEI incorporates by reference the allegations contained in the preceding paragraphs of this complaint. TEI is the sole owner of the copyrights in the Nuke and registered it with the USCO. Caseytron accessed the Nuke from TEI's YouTube channel, H3H Productions. TEI did not grant any license authorization or consent for Caseytron to exploit the Nuke in any manner. Due to Caseytron's acts of copyright infringement, TEI suffered damages. Due to Caseytron's access of copyright infringement, Caseytron obtained the profits they would have realized but for her infringement. Caseytron's acts of copyright infringement were done with an actual constructive knowledge of the rights. I think he just called Denims and Frogan Hassan's waiting room there. I mean, technically, yeah. And then the second claim for infringement, which is the one that we're kind of the most iffy on, is this is all about the H3 snark mods. Completely, like, start to finish. And it's also copy-pasted in every document. And then his prayer for relief, TI be awarded defendants and each of their profits, plus TEI's losses attributable to defendants' infringement of the Nuke, the exact sum to be proven at the time of trial, or, if elected, statutory damages in the amount of $150,000. TEI to be awarded its reasonable attorney fees and cost. TI to be awarded pre-judgment interest as allowed by law, and TEI to be awarded such further relief as the court deems proper. And then just at the end, jury trial demanded.
Yep. Bada bing, bada boom, zoom.
But that is the whole thing of this case. In the other cases, there's a lot less H3 snark mods, and there's a lot more argumentation over like facts and shit. He still does like this big sourcing thing constantly. I like this one.
Yeah, I will say there's quite a bit more fat on this than there needs to be, but it's still a strong case regardless, and I have a feeling it's gonna move forward to discovery.
You know, I see it moving forward for sure. It's so annoying to read.
Now, I don't know exactly how the case is gonna go, but he's definitely met like what he needs to meet for to have it move forward.
Yeah.
As annoying as that is.
So chat, we need to clarify this because a bunch of people on Twitter don't seem to understand this. Anybody who tells you Ethan is like 100% won this case already is lying to you. You never know how a court's gonna go.
Yeah, that's why I use terms like strong case, weak case, etc. Because there's just, even as a lawyer, it's not this is a flam dunk, this is, and like, if you speak like that, you're kind of speaking out of a little bit of ignorance there, because these cases can go down either way, depending on the judge's discretion. I mean, again, when it comes to copyright law specifically, you can have one judge rule as something be fair use and the other one not over the same exact 5 seconds of content. So this could still go either or.
Yeah. In chat,
there are no absolutes, exactly.
But everybody wants you to think there are, just because the case is like strong or weak. Like, you could just, it's completely possible you just catch the judge on a bad day and he just says, fuck you. And you can probably mistrial it, but sometimes, yeah, you just get a judge on like a bad day and he says, fuck you, you lose. I don't think we're gonna go over this one, chat, because it's another 32 pages and we could be here like all day. Because we've already gone like 4.5 hours. But we did want to touch on this because this is another fair use case that just went through about AI. And ultimately what happened is a court has determined that you can use like media and stuff to train an AI and it does not violate fair use. And this comes from like a lot of people not understanding realistically how the court is going to rule on AI, because a lot of them seem to think that like there's some secret corruption going on with the AI lobbies or something, which no, realistically what's just happening is the courts realize that they can't realistically legislate away AI without causing mass damage to the market in general.
Yeah.
Because I've sat down before and I've tried to think about it, like if I was a judge or a lawyer or something, or like even just like a lawmaker, and I had to sit down and write out like a law to legislate away like generative AI, it would be like impossible for me to come up with a wording that wouldn't negatively affect like digital art in general, or like people taking inspiration from others. It would have to be so hyper specific that the law might as well just say, I ban generative AI.
Yeah.
That's the best I could do at the end of the day. But I think this is just what the conclusion to it. Which, chat, the conclusion to this AI case is 32 pages.
Yeah, I think actually you can get down, if you go down to the very bottom, I think there's like a conclusionary statement at the very, very bottom.
So with respect to
paragraph.
the training copies and to the print to digital converted copies, this order has drawn all ambiguities and inferences in favor of the opposing side, namely authors. With respect to the pirated copies, this order has also accepted the author's version of the facts. Authors did not move for summary judgment, but if they had, we would have been obligated to accept all reasonable views given the evidence in defendant's favor. The order grants summary judgment for Anthropic that the training use was a fair use, and it grants that the printed digital format change was a fair use for a different reason. But it denies summary judgment for Anthropic that the pirated library copies must be treated as training. We will have a trial on the pirated copies to create Anthropic's central library and the resulting damages, actual or statutory, including for willfulness. Anthropic later bought a copy of the book it earlier stole off the internet will not absolve it of liability for the theft, but it may affect the extent of statutory damages. Nothing is foreclosed as to any of the copies flowing from the library copies for use other than for training LLMs. It is so ordered. So basically, some of the stuff they had was pirated, some of the stuff they had wasn't. The stuff that wasn't pirated was deemed fair use. The stuff that was pirated was obviously determined to not be fair.
There you go.
So basically, the conclusion this kind of comes to is if the AI has legal rights to touch the work, it is now fair use. At least that's how I read it. Not saying that's how it's going to work in every case.
Pretty much going. No, but at least in this one, that's how it ended up boiling down.
Yeah. And this is something
like
also...
Nico Matan says, using art to make a tool capable of producing arbitrary original works is as transformative as you can get IMO. And yeah, it kind of is.
Yeah. It's very difficult to make an argument that it's, that AI is not transformative without heavily damaging art in general. As like an entire field.
No, because I mean, I've done even just playing around with ChatGTP. I've given it like an image of me and like something I wanted as a background for the thumbnail, and it put me in a slightly different position in the picture, and even like the expression was a little different. Like it redrew me, and it redrew me like at least 40% different, right? Everything from my stance to my expression itself. I'm like, this is inherently transformative. This is not what I gave it. It's what it came out with, but it's not what I gave it.
Well, because even if you say AI can't make new things, they can only reproduce what's been fed to it. Even if an image is just like a kit bash of like 500 different images, that's still transformative. Like, that's kind of the weird line you end up on. And the only way to legislate that out is to damage digital art as an entire medium permanently. Which is why I've said, like, the problem is if you tried to legislate it, it would be impossible, basically. It'd cause more problems than you'd solve. Also, don't be mean and fighting with each other in the chat. We're all allowed to have polite disagreements here. We're not like the Twitter lawyers. Trying to yell at me.
Yeah, I looking at look, buddy. You have to be careful. Look, cause the one I saw swing at you is the one who schooled the shit out of me about the copyright being federal thing. Like, again, I'm a lawyer. I totally forgot about that. I am ashamed. But like, talking with lawyers on Twitter in general is going to be adversarial in nature. And I know you discovered that in that little back and forth between him.
Oh, yeah. See, I didn't expect him to like immediately get like, what the fuck is wrong with you? Like, okay, calm down, buddy. We're just talking. Let's be chill for like 5 seconds, dude.
Look, it's hard to turn off that like contrarian nature that you get as a lawyer. It's part of why I stopped practicing and I turned it off years ago. So I'm good. But like, yeah, I watched how that went and it went exactly how I knew it was going to go. But you stopped it earlier than I thought most people would. Most people would have continued until they were a mess. You actually went, okay, look, like, I'm not trying to do this right now. Like, this is all I'm saying. And like, you quelled it pretty fast. Most others wouldn't have. Even other lawyers would have crashed out over that. In fact, other lawyers have. I've seen him crash out with other lawyers, especially over the Karen Reed rulings.
Did you see that he tried to poke me again an hour ago?
No, I didn't.
An hour ago he posted, hey, are you gonna respond?
Nah, don't do it.
I was like, no, I'm not going to. I don't care. I don't do like this fighting thing with people.
I get in discussions for fun, and this isn't fun.
Yeah. Also, you know why I don't fight with people, chat? Because I'm always correct.
Oh, Jesus Christ.
I'm always
I still
right.
love that redone meme was like, dude, you have a superiority goblet. But I seriously, I read that meme and I read it in your voice. I am superior.
Oh, so, fucking Pirate Software is still responding to the Stop Killing Games initiative.
Yeah,
Apparently
I'm planning on reacting to that tomorrow.
Another post about it. About 3 hours ago.
Did he really? Yeah, tomorrow the algorithmic hold on, Accursed Films' response to, Pirate Software, like, we're gonna react to that tomorrow. And I think that's gonna be, like, pretty much the only video we react to, because it's gonna take up most of the time. But I'm going to be adding, any responses from Thor and stuff like that, because I've only seen, like, 2 clips, and it looks like Accursed Films just kind of, like, hammer space Thor in terms of, like, no, this isn't what I meant at all. I don't know what the fuck you're talking about.
Yeah. I sent, like, a link to the tweet for you. He's already got a pending community note on it.
Does he really?
Yeah. It's not, the community note's not there yet, but it's still pending.
Yeah, it's kinda, yeah, I gotcha.
It's so funny. Like, he just can't be like, yeah, I'll take an L. He's just gotta fight it over and over again.
No, he can't. Remember, the content creator psychologist came out and said he's neurologically incapable of it,
Yeah.
so... Oh my god, this is so long. Oh my Jesus Christ. Pirate Software, dude, you can't just like, yeah, you're right, I take the L here. This is too long, man, just take PL. Huh. One of the few times I've ever agreed with the Saku.
Yeah. Like, at best, he could just, like, stop talking about it and people might forget about it in a week, but he's like, no, I gotta keep fighting.
He's gotta fight the good fight. Him and the Roach King. Careful, he might... Yeah. Oh, speaking of, Anarchy Studios did finally manage to get Steam to get off their ass and properly put on Idle Streaming Bonanza on Steam, so that's up and available for purchase.
Fair. What, chat? I think we had a good stream today. What do you think, Ava?
I think we did. It was a lot of fun.
Sorry we didn't get around to reading through the whole AI training thing. I actually did not expect us to spend as long as we did on...
There's a reason I chose the shortest complaint.
But chat, you all have a good day. I will be back tonight for repo. Ava is also always welcome. But if Ava's busy, Ava might not be there.
Yep, I might be able to, I might not. We're gonna have to see, but we shall see.
And I'm gonna send you guys over to Lum Lum. It'll be good for Lum Lum.
Yeah,
she's doing
Warhammer
today. Bye, chat.
Heck yeah.
I give myself one more head pat before I leave. I deserve it.
Yep.
Peace out, guys.